The Honorable, the Judges of the United States Court of Appeals to the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw an eye and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, first case we're going to hear this morning, United States versus Pittman. And Mrs. Laddie, is it 3 syllables or 2?
It's Rattlade. It's kind of
Rattlade.
like
Thank you. I'm sorry, Rattlade.
Put together.
Thank you.
May it please the court. My name is Heather Rattlade, and I'm here on behalf of the defendant appellate Charles Pittman. It is an unconstitutional exercise of Congress's power to prescribe the arson of a city-owned landmark when it is not used in any commercial activity, when it was not used in any activity affecting interstate commerce, when it did not benefit from any federal funding by acquisition, maintenance, nor renovation. It was not occupied nor used by an organization or agency primarily funded by the federal government, and it's never been utilized by an organization to effectuate a national program. The spending, property, and necessary and proper clauses give Congress the power to enact laws to ensure recipients or beneficiaries of federal funding use those funds as intended, to prevent waste and fraud, to promote the general welfare of the nation, or to protect some actual and substantial property interest of the federal government. Since none of those interests are implicated in this case, there's simply no legitimate rational basis for the federal government to encroach upon the state's general police power. Mr. Pittman therefore prays this court will remand and instruct the lower court to dismiss with prejudice.
So can I ask you a threshold question about what your argument is? Is your argument that the statute should not be construed to cover my client's conduct because that would be unconstitutional, and so the statute doesn't cover him? Or are you conceding the statute covers him and arguing the statute is unconstitutional as applied to him?
It is unconstitutional as applied to him.
So that, okay, but that seems like an important concession because there's arguments in your brief that sound in we shouldn't construe the statute as to apply to him. But now are you conceding that the statute does in fact apply to him?
I'm saying the statute as it is applied to him in this case, given the context.
Okay, so that, at that point, things like the rule of lenity and all go out the window because those are canons for construing the statute. But if we assume the statute applies to him, then we're not talking about canons of construction or anything like that.
Well, if you look in Lopez and you look in Bass and you look in Bond, when you are looking not only to the construction of the statute and whether or not that construction as applied to the defendant, then the interpretive canons do come into play as just...
Well, I know. That's why I think it's a really important question, whether your argument is that properly construed, including all these constitutional avoidance considerations, that the statute does not apply to him, sort of like with the First Circuit. I'm sort of adopting the First Circuit's gloss on the statute. But that's a statutory construction holding. That's not a constitutional holding. And I guess I'll just preface that I don't understand how, by pleading guilty, a defendant doesn't waive the argument that the statute properly construed does not apply to me. I understand under class you don't waive a constitutional challenge. You can always say this statute is unconstitutional, but I don't understand how you can plead guilty and then say, even though I pleaded guilty to violating the statute properly construed doesn't apply to me.
I am saying that the statute is unconstitutional as it's applied in this case. And under class, that issue is not waived when you read the plain language of his plea waiver.
And that's because there's nothing that he necessarily admitted to as part of the plea that would make the statute, is that how we, so class is a case where the defendant is arguing this statute isn't constitutional really as applied to anybody on earth, right? Like that there's, or Lopez is a great example of that. The defendant in Lopez doesn't say the statute is unconstitutional as applied to me. He says this statute is unconstitutional as applied to anybody. But you're sort of making the next order because you don't argue this statute is unconstitutional as applied to any arson, right? You agree there's all kinds of arsons this statute is perfectly constitutional as applied to, but your argument is that there's nothing that my client admitted to during his plea agreement that makes the statute constitutional as applied to him. That's the argument?
Correct.
Okay.
the guilty plea didn't bar this particular challenge.
Because he didn't make any admissions that are in, so like class has language that says like.
We're not challenging the guilt. We're not challenging whether he's guilty
Okay.
or the facts of his guilt at this point. We're challenging the constitutionality of this statute as it's applied to Mr. Pittman.
Well, then you went right to the spending clause. Can I ask you about that? Why doesn't Sabri just pretty badly cut against your argument that this couldn't be sustained under the spending and necessary and proper clauses?
Sabri was a case that challenged the applicability of, or 18 USC 666 as it is applied to a developer. In that case, he had tried to bribe a councilman. The spending clause, the Supreme Court held that that statute, as applied in that case, was certainly constitutional because the government had the power to make sure there was no waste and that corrupt officials didn't misuse federal funds, however those funds would be. I think the court specifically said that to ensure that federal funds are not frittered away and grafted on projects undermined when funds are siphoned off or corrupt public officers are derelict in demanding value for dollars. This case is different because it really turns on the city of Fayetteville.
Right, and so just
receives,
take the language from Sabri that talks about how money is fungible and I have to spend money on X, I can't spend money on Y, and just say, okay, so if someone burns down the market house, the city of Fayetteville has to spend money to deal with that, which means money that the city of Fayetteville would otherwise spend on other things that now can't spend on other things, which means the federal dollar is going to go less far. It just seems like the sort of rationale of Sabri seems to just apply here to me.
first, the government's fungibility arguments to justify applying 844F to Mr. Pittman's conduct, they're fundamentally flawed for three key reasons. First, the city is more so a conduit of federal funds rather than a beneficiary. Fayetteville acts as a conduit for the federal grants, not a direct beneficiary. Less than 1% of the city's operating budget comes from federal grants. Most of that money benefits private citizens or nonprofits, public or private nonprofits. Some of those public nonprofits are agencies of the city of Fayetteville, such as the Fayetteville Housing Authority or the Piedmont Water Company. Agencies include the police department, the economic development department, the airport. Under the Hersom rationale, Fayetteville does not meet, the city of Fayetteville as a whole doesn't meet the definition of an organization receiving federal financial assistance.
Well, but now this is now an argument the statute doesn't apply to my client, which I thought we agreed you've basically forfeited by pleading guilty.
I haven't agreed to that.
Well, I thought you just did.
I'm sorry.
I thought we had a constitutional claim. In other words, if Fayetteville's not an organization or an institution, it seems to me that you made that in your brief, but number one, he pled guilty to it, but number two, Fayetteville is a North Carolina corporation. It's a municipal corporation, and I don't know whether that gets you very far, especially when you pled guilty to the statute.
Correct.
I thought you were focusing, you agreed to focus and couch your argument only on the constitutional claim.
Yes, sir. Well, to the extent, we are not challenging, he's not challenging the facts of his guilt. That's not an issue. It's the interpretation of the statute
But
as
didn't the
it's applied
indictment
in this case.
But
And
doesn't the indictment allege that Fayetteville is an organization under the statute?
yes,
Didn't he plead guilty?
yes.
So doesn't that mean he admits that Fayetteville is an organization under the statute?
Yes. Next, even if Fayetteville's an organization under the statute, there are absolutely no federal funds tied to the Market House. The city of Fayetteville has never received federal funds for the Market House. It has never used the Market House to carry.
Doesn't that overlook the fact that funds are fungible, that federal funds, Fairfield clearly receives federal funds. And the traditional notion, as a condition of receiving them, the federal government gets to do some regulation.
Exactly.
Congress does it. They don't have to accept those funds.
Which goes to,
But they did accept those funds, and Congress said anybody that receives our funds has to comply with the provisions of Section 666, or in this case, Section 844.
which goes to the third argument, the limited scope of federal grant money. Federal grant funds are earmarked for specific purposes, and misuse of those funds carries financial and criminal penalties. And if we want to go back and look at the Sabry case, what's so important about that is when you look at the definitions or the first section of Sabry, I think it's 666A1, and if you were to construe that in parliamentary.
I don't think the law treats the city as a sovereign. The state and its agencies is a sovereign, but the cities are municipal corporations and are treated differently.
Generally, yes, that's true. I think when you look at 666, what's really important is that Congress specifically said that an agent of an organization, an agent of a state, or local or tribal government, or agency thereof. So even in Congress recognized that the local government didn't fall under the term organization in 666. But going back to the constitutionality of this, it's very important this court looks at the clear statement rule. Because if we're going to look at the constitutionality of the statute for the federal government to encroach on the state's police power here, it's critical that we look at Congress's intent. And what is clear from the legislative record is that they explicitly intended it to apply to fires that damage property owned, possessed, or leased to the United States or federally funded organizations or institutions. And the section, the House report also goes on to say, such as universities, hospitals, police stations. They did not clearly and explicitly say that this applies to an entire city. The police station itself is an agency of the city. So if he had set a police car on fire, given the amount of federal funding that goes towards police departments, yes, you could prosecute this case. And even if you look at every single case that is cited by the government in their brief and my brief, all of those properties have a federal interest. It's either a Planned Parenthood building, which the court found was an instrumentality of the state.
Is this
it's a
covered
house
by the
that's funded with
national-
Section 8.
Is this covered by the National Historical Preservation Act?
The National Historical Preservation Act, that argument also
No,
fails.
my question is this covered by it? Is this property covered by the act?
I'm not as familiar with the National Preservation Act, but the National Historic Landmark Registry that it is
Isn't it the
on.
National Historical Preservation Act?
I'm sorry?
Isn't it the National Historic Preservation Act that's involved here?
Yes, and it's listed on a registry, which essentially, and if you read
And
that
doesn't Congress
statute.
have the right to enact provisions necessary and proper to give effect to that act?
However, the National Parks mission page specifically states that the federal government is not preempting any state law with regard to those properties. And it explains that most of those National Historic Landmarks are, quote, owned by private citizens, organizations, corporations, federal, state, or local governments. The federal government owns fewer than 4%. The laws that govern those property rights still apply to landmarks. However, the designation of a property as a historic landmark does not give ownership to the federal government,
doesn't
nor
require
authority
ownership.
to
It just-
regulate anything with regard to that building.
The act is just to preserve historical properties, and this particular property is covered by that act. And it seems to me Congress could enact statutes to give effect to that act.
Congress we have to go back to what is the federal interest here? Is there a federal interest for them to, whereas
Are you
Jones
arguing
versus the
that-
United States
are you
clearly
arguing-
says that arson is a quintessential
Are you
crime.
arguing that the National Historical Preservation Act is unconstitutional?
No, I'm not.
Okay, well, if the act is on the books and this is registered under that act, doesn't Congress have authority under its necessary and proper clause to protect that property with various statutes of different kinds, including a statute not to destroy the property or damage it?
They can, but that's not the intent of why this statute was passed, number one. But number two, they can't control what happens to that property. Fayetteville could decide to sell it. In fact, there have been many meetings about whether to move that to a museum instead of where it is now, given the history of that building. But Congress and the federal government can't control what Fayetteville does with that market house or any landmark that it owns or any landmark that you may own or the Daughters of the Confederacy may own.
Anything else?
The last point that I want to make very quickly is Congress explicitly explains what the purpose of this statute was for. And it was to allow the federal government to be involved when there was some substantial interest of the federal government. And they named, it spawned from the ROTC bombing, I think, at the University of Wisconsin.
Okay.
But when you go back and you look at all of the cases throughout that this government has cited, all of those properties have a federal interest, whether it receives Section 8 funding, whether it was Planned Parenthood, that 40% of their budget comes from the federal government, whether it was a police department or a sheriff's department or a courthouse that housed the Department of Agriculture.
Why don't we have you continue on your rebuttal? I see you're
I'm sorry.
over time.
I'm sorry.
You've got 5 minutes, and we'll have you back.
Thank you.
All right, Mr. Bragdon.
May it please the court, I'm David Bragdon, and I represent the United States. On the constitutional issue, there are two bases for why this is within Congress's constitutional powers. One is under the spending clause and necessary proper clause, and the second is the necessary proper clause as to it being a National Historic Monument. The two cases that I think are the most relevant on the spending clause, necessary proper clause, are Comstock and Sabry. Comstock, because it sets out the general standard for looking at whether or not something is necessary and proper. And I'd like to just point to a couple things in that regard. The standard is whether the law is a means that is rationally related to the implementation of a constitutionally allowed power of Congress. So is this law rationally related to Congress's spending clause? And in Comstock, the court specifically said, we give Congress a lot of deference in that. And so we're not going to, as long as it's intended for that purpose, we're not going to second guess the means or the connection of the means. Sabry then is an application of that principle to the spending clause. And in Sabry, there was this question of, well, okay, here, what if the money isn't related to federal funds? What if the bribery or the corruption that's being dealt with is not connected with federal funds? And they said, no, Congress has power to go beyond that. It can look at, because corruption, money's fungible, and it's going to affect across the different kinds of money involved. And so we're not limited in that way. And I think the application here is very similar in that you have this You have Fayetteville receiving a lot of federal funds. My colleague identified some of the different areas, but there's a lot of areas. There's some attachment in the record to that effect. But if their buildings are burned, if their things are burned, even if they're not the ones that specifically received federal funds, that is certainly going to affect Fayetteville's ability to carry out the various objectives and goals Congress.
What difference does that make? I mean, the government, federal government is not here to make sure that the city has enough funds to operate. I mean, that's the state of North Carolina. The question is what funds that they're funding. They don't use any funds to fund the market house. No funds were given for this, to build it, to maintain it at all, correct?
There were funds allocated, but they were never actually spent. So twice funds were allocated.
How long ago was that?
Actually, fiscal year 2020. So during the time period of the burning, funds were allocated. There's nothing in the
So no money was spent.
The money was not spent. That's correct, Your
Right.
Honor.
And the facts of this case doesn't implicate any question about fraud or abuse, does it?
This is a different situation than fraud.
Very
certainly.
different situation. This situation where a building is not, no funds, no federal funds were used at all. No question about any fraud. And you're saying this statute is broad enough to cover anyone any organization that receives federal funds without any connection to fraud nor the building itself or the property itself, correct? That's your position?
Is the court asking me about statutory
I'm asking you,
interpretation
no,
or
I'm asking you.
constitutional?
Yeah, well, constitutional question.
Oh, okay, yeah. Yes, we do think it's broad enough, Your Honor.
Well, then if it's broad enough to do that, then that would also include, for example, church property would be included too, correct? If a church received funds? For example, some churches.
Any nonprofit organization that received federal funding, yes, Your Honor.
So that means that in any property, right?
Yes, Your Honor.
And without any restrictions of the amount of cost or the value of the property, correct?
Yes, Your Honor.
So that means that, so for example, if you had an organization that received federal funds and they were having an event and they put up paper signs and said, don't park here on Tuesday because we're having an event. And the person is angry about it because they normally park there and they take their lighter and light it up. That's a federal crime, right?
So I think you're talking about burning the sign?
Yeah, it's their property because there's no limitation of amount.
That may be covered, Your Honor?
No, maybe, no, wouldn't it be covered based on your interpretation of this statute?
I believe so, but the court looks at the constitutional issue as applied. And we're not saying that every single application of this statute is necessarily constitutional. What we're looking at today is this application of the statute constitutional? Fayetteville received.
Why do you temper it like that? The statute is unqualified, that any organization that receives federal funding, property of any organization is protected, in other words, by a federal law.
I agree that it's covered by the statute.
And the link is that the organization receives the funding, not that a particular property receives it. And we have tons of federal statutes governing situations where there's federal spending. People don't have to receive it, but if a church receives federal funding, it knows that it's going to be subject to federal law.
That's right, Your Honor.
That's not the question here, whether or not they're subject to regulation. This is a criminal statute. This is a criminal statute. And the question is what they're trying to do is to use the normal conventions to otherwise do what's the state crimes and make them federal crimes, which is normally through interstate commerce or spending. That's the question. It's not whether or not they may be subject. Certainly they are. If you receive federal funds and you're providing health care, you're going to be subject to federal regulations of providing that health care. This is not that question. The case is you're saying that just because the city of Fayetteville receives federal funds, it doesn't matter whether there's any connection to spending on this property at all. It's just an omnibus. And you can just go in federal crime. Because is anything to prevent the state from prosecuting these crimes? It's just an arson.
The state could have prosecuted the crime as well. And in fact, the law that creates this federal crime specifically says it's not superseding states' abilities to prosecute, these crimes on their own. So certainly,
So there's really no need for the federal government here to really do this. In other words, you select, when you clearly select, but you don't do it based on whether or not, you could say, we only use this when we pay for the property destroyed, but you don't. You can use it, for example, like I suggested, I guess you conceded that sometimes the application, and Judge Niemeyer said, would say you shouldn't do that, but I think you have a right to the government to concede what you want. But it makes sense to me to concede some of it, but you say that this, you can get federal jurisdiction solely because the city receives federal funds without any connection to the property, without any connection to fraud at all, or conspiracy, and that was the whole idea. If you look at the legislative history, it was to try to get at organized crime and things like that. But that was the way to get sort of getting into the tent. But once you do it, this was a protest based on what in this case? We haven't talked about it.
it was based on, it was Floyd in the aftermath
Oh,
of
who?
George Floyd.
He made his killing
Yes.
in Minnesota. That was
Yeah, it was.
And then the government.
It was following that. There were protests.
And the government prosecuted the case under this statute, right?
Yes, Your Honor.
Okay.
And this statute was actually passed, the bombing portion of it, relating to buildings on college campuses being bombed related to the Vietnam War. And so there were these ROTC buildings, and if you look at the legislative history, they talk about, we want to protect these buildings that receive federal funds and other buildings on campus.
It makes sense because the buildings were used with federal funds to build them.
No, a lot of these buildings, that there was, it said these buildings and other buildings. And so even from the legislative history, it's clear that they want to protect these college buildings. They want the ability for the federal government to assist the states in the investigation. I think there was a vision that there would be federal resources to be able to look into these things. And there's certainly going to be times when the state and federal interests are not completely aligned. And so Congress has the ability to protect the organizations that it funds. And if an organization, you gave the example of a church, right? Let's say money is provided for the church to be able to send, to do certain service.
Operate a soup kitchen or adoption services or something.
Yeah, operate a soup kitchen or adoption services. If the church building gets burned down, that very well may affect their ability to perform those services. And so Congress it's not just arbitrarily saying, hey, don't do anything, we just want to add these extra rules. It's adding rules that helps its funds to be used for the purposes they're intended. And
Can I
it's
ask you about
allowed to do
forfeiture?
that. What's that?
Can I ask you about forfeiture? Okay, so let's see if I can get some agreement. You agree that under class, he's allowed to make some sort of constitutional challenges. The fact that he pleads guilty doesn't take those away, right?
And I would say that. I would say we did not assert the appellate waiver in the plea agreement here.
Sure.
And so I don't want to foreclose that kind of argument later, but
Sure.
certainly as to the plea
Well, but the
itself.
appellate waiver seems different than the argument rejected in class. The argument rejected in class is like there's just something
Yes.
inconsistent about saying, yes, I did it, and then arguing, actually, you can't prosecute me.
We
But
agree
the
with
class deals with that.
Yes.
Okay, so, but you argue that it's forfeited because he didn't make a timely motion to dismiss the indictment. I will confess I find this area really confusing because, like, how forfeiture rules work in this context. Because you agree that I think it was the initial appearance, he did raise arguments that sound kind of like the arguments he's making now?
Yes, he raised that concern as a reason to oppose bail. So he didn't ask.
Have you encountered, I mean this is a genuine question because I'm not, are you aware of any cases that confront that kind of situation and ask whether it's forfeited? Because I'm not sure I was able to find anything particularly on
I am
point.
not aware of a specific case, but I will say the Fourth Circuit has cases, and I think In re Sealed case is one of them, where it talks about the objection needing to be specific. And so I think if you raise a point as an argument of why I should be released, that's very different from making a motion
But
to dismiss.
his argument was I should be released because properly construed, I didn't violate the statute, right? Like it wasn't I should be released because I'm not a danger, I'm not a flight risk. I mean, his argument why he should be released is because you can't prosecute me for doing this.
Absolutely, but he never followed up that with a motion to dismiss. And so there was never a point where the court thought, okay, he clearly thinks that this statute is beyond the constitutional power, or his conduct is beyond the.
I guess part of the argument of forfeiture rules is you're not allowed to basically sandbag district courts by asking us to reverse based on something you never asked the district court to do. And I guess you could say here, well, he never asked the district court to dismiss the indictment, so the district court had no occasion to decide whether to dismiss the indictment.
I think that's absolutely right. The other thing I'll add to that, Your Honor, just as a practical standpoint, is the detention hearings are heard before magistrate judges. When they're not appealed, the transcript is never made. And so the district court judge likely wouldn't have even necessarily known of this argument that was made before the magistrate judge. So I think that's another argument for why it would not.
Can I ask you something about Judge Niemeyer? Under what grant of Article I authority did Congress pass the National Historic Preservation Act?
I think it's not clear.
Right.
There's a couple of things that I'll say. I think I believe there's a statutory reference to the Commerce Clause in there. The legislative history.
But the act clearly covers some buildings that don't affect interstate commerce.
The act, it covers a variety of different things, right? So, certainly some things are covered by Commerce Clause, other aspects are covered by property. The legislative history mentions the property clause specifically. I did not see anything that mentions the spending clause, but given that Congress is specifically referencing the receipt of federal funds, I think it's fairly clear that they intended at least that portion to be under their spending power. But more importantly, the Supreme Court has held that when it's an issue of constitutional power, the court looks at whether or not the power exists, not whether or not Congress specifically identified it.
Oh, no, I agree. I think Sebelius just says that. But there is the question under what power they passed this act in the first place.
I don't have a clear answer to that. I see a couple things in the record. I don't see a specific reference.
Or let me rephrase. Under what grant of authority they could pass an act like this, regardless of whether it's the one they specifically relied on.
Right. Yeah. So
Is it your position that just being designated as a historic landmark alone is enough for jurisdiction under spending power? In other words, no funding at all. It's just you're on a register.
yes.
It just gives you clout. You think that's enough?
Yes.
Government's clout.
Yes.
This statute, it has no limit. It's just as broad as it can be. Normally, people who normally defend federalism be jumping up and down, but I mean, this basically is an incredible reach. Just because you said, okay, a lot of times private people said, as counsel said, own these properties. They said, we want to make this designated because it was 100 years old, it was antebellum. And then you said, okay, you're on the list, you're antebellum, and that'll help you. That gives you jurisdiction for the spending clause just because you designated that. No money being spent. We're going far afoot. I thought the whole idea about this situation is that the federal government is a limited government in a federal system. And statute, this gives what, 20 years in prison? I mean, that kind of thing, potentially, right?
I do believe that
and
was
you're
a
saying that
statutory-
just by burning up a piece of paper, for example, in an organization that receives funds when they have a parking sign, or you said, I don't know, that gives you 20 years in prison, a federal crime. Because there's no limitation. Because you jump to, well, if you burn down a church, certainly if you burn down a church, maybe the overall, but it's not that. It's every flyer they might have. They might be carrying their message along and you burn their flyer up. That flyer belongs to them and you destroyed that flyer, right? That would be included in the statute.
It would be included, Your Honor. I think
20
it
years
would
in
be-
prison for that.
It would be a closer constitutional question, in my opinion. I think in this case, yes, the statute is that broad. When we look at the constitutionality of it, we look at it as applied. We don't look at the hypothetical flyer. We look at the city of Fayetteville receiving $20 million. We look at it, it received more money from the federal government than it received from the state government. Its money was a mix of federal, state, and local, but it received more money from federal than state. You have a building that was a National Historic Landmark. Nobody has challenged that law, the creation of National Historic Landmarks. And so I think in these circumstances, it is constitutional. I would write a completely different brief.
It seems to me you're blurring the issues. I think if the Preservation Act is not being challenged here, we don't have a constitutional question. We basically have the question of whether Congress has the authority to give effect to that act by prohibiting the burning of something that's on the historical register. And the act was clearly designed to protect buildings on that register.
Yes.
I mean, we have not identified the source for the Protection Act. And the constitutionality of that act is not being challenged.
I agree. I see I'm about out of time. Does the court have any questions related to the statutory construction questions in this case? Seeing none, I would ask the court to affirm.
All right. Thank you, Mr. Bragdon. All right, Mrs. Reddeley.
Thank you, Your Honor. First and foremost, the lower court held that Mr. Pittman's conduct was prescribed conduct fell within Congress's power under the Commerce and Necessary and Proper clauses. In doing so, he disregarded the Supreme Court's holding in Jones by broadly construing 844.
Why are you going to the Commerce Clause?
Well, that was a question that was hard to understand because 844I covers property that falls under the Commerce Clause. I can't answer, his rationale for that. But his conclusion cited some of the other cases, including Brown.
But I think the difficult question for you to address is whether Congress has the power to enact a statute that
Congress has the
is applicable
power.
to property of an organization that receives federal funds. That's the qualification, receiving federal funds, right?
That's the qualification as it's applied here, yes, Your Honor. And under the National Historic Preservation Act, going back to that particular issue, it directs federal agencies to take into account the effect of any undertaking that is federally funded. So if under this Preservation Act, if somehow the city received funding from the federal government to renovate, restore, or preserve that, then certainly his conduct would fall. It would be constitutional to apply this statute to him. But because that property has never received that, we're saying it's not. And if even you look at the Justice Manual, in Title IX of that manual, it specifically says that there has to be, quote, absent a specific federal interest, the government will not become involved in local matters that can adequately be investigated and prosecuted by state authorities.
Well, you still have a couple of minutes. Could I ask you to respond to the government's argument that this is forfeited?
Well, it isn't forfeited. I filed an extensive motion to dismiss with extensive briefing. We had an extensive oral argument, and then we had post-hearing memorandums.
Right, but you didn't file a motion to dismiss the indictment within the time prescribed. No, I know it wasn't. Let me rephrase. The defendant did not file a motion to dismiss the indictment within the time prescribed for filing a motion to dismiss the indictment. That's not disputed, right?
No, I did not.
I'm not asking whether you. It's your client. I understand you came in later, but the defendant, and there is a deadline for filing a motion to dismiss the indictment. The defendant did not file a timely motion to dismiss the indictment. That's undisputed, right?
That's true.
Why isn't that a forfeiture?
Because the defendant can raise the question of jurisdiction at any time.
Well, this is not jurisdiction. We've said that before. Yes, occasionally.
Constitutionality of it being applied.
That's not subject matter jurisdiction. You can waive you can forfeit constitutional arguments. People forfeit constitutional arguments literally all the time.
If you read class in the
I have read
fact
class.
pattern of class in how that came about and when yes.
No, I agree it's not waived, but the argument
you have to answer these questions, Court of Appeals.
The argument in class was that it was waived.
Right.
And the argument that class rejects is that it's waived. Class does not address the question of whether it is forfeited or, and as I recall, I'm admittedly trying to remember something. I believe the defendant in class did file a motion to dismiss the indictment, didn't he? He filed a motion to dismiss the indictment, it failed, and then he pleaded guilty. But he filed a motion to dismiss the indictment. Right?
We did not file a motion to dismiss. I did not become involved until after he had pled guilty. But
Sure.
going back to what you were talking about before, as far as organizations receiving federal financial assistance, if the court looks at HRSA and you look at, they looked at the meaning of organizations receiving federal financial assistance, and they construed that definition in relation to the civil rights statutes. And they cite Grove City College versus Bell. Grove City said, hey, we opted out of federal funding, so no, Title IX doesn't apply to us. Oh, no, said the Supreme Court, because the student received federal financial aid, and that aid went to pay for her education there, so they were a beneficiary there. And then going back to speaking about the buildings and buildings being burnt down on college campuses back then, college campuses had started receiving federal funding to implement programs on campus. So, all of those buildings have some specific federal interest. In this case, there is none. Under the government's arguments, you could prosecute someone for burning a trash can that's owned by the city of Fayetteville, which would seem absurd. Even the government, when you gave the church example, the government said, well, sure, you could, as long as they implemented some program that was funded, like soup kitchen. Well, that's not what we have here. We have just a landmark that stood alone, nothing else. No federal funds were ever appropriated to that landmark or used.
Thank you. I notice you're court appointed, is that correct?
Yes, Your Honor.
I'd like to recognize your service to the court. This is a very important service, and you've done it well. And we'll come down and greet counsel and proceed on to the next case.
Thank you very much, Your Honor.
D. Michelli, whenever you're ready, we'll hear from you.
Good morning. May it please the court. Andrew D. Maselli on behalf of the state appellants in this case. Under the highly deferential AEDPA standard, it is the habeas petitioner's burden to show that the state court not only misapplied federal law, but that its decision was so objectively erroneous that it was unreasonable beyond all fair-minded disagreement. The Appellate Court of Maryland's application of the Brady materiality prong in this case was consistent with Supreme Court precedent and entirely reasonable. Rather than affording that decision the deference that the AEDPA statute requires, the district court in this case substituted its own Brady materiality assessment and granted federal habeas relief to Mr. Martin. That was error, and we submit that this court should reverse. I'd like to address a number of facets of this case, but I would like to begin, if I could, by highlighting what the state court got right in this case. First, the court correctly articulated the Brady materiality test. It cited all of the applicable Supreme Court cases, including Brady itself, Agers, Bagley, Strickler, and Harrington. The state court, assuming that the suppressed computer analysis report would have totally discredited Sherry Carter's testimony, was a reasonable application of the Brady materiality prong. It held that Martin had not met his burden of showing that had the computer analysis been provided to the defense, there is a reasonable probability that the result of his trial would have been different. It is entirely consistent with U.S. Supreme Court precedent. It was not a sufficiency of the evidence test, as Mr. Martin suggests, but
Can we agree that the state court at least at a few times used some language that could have been more precise?
certainly, I think most of
They use some language that sort of starts to sound like sufficiency, right? I mean, I agree they quoted the correct standard several times, but they also, a few times in shorthanding, it starts to say things that sound like sufficiency to me.
I think that the court was simply weighing the strength of the state's case, which, as we've argued in our brief, I think quite thoroughly, that is an entirely reasonable application of rating. Under the Supreme Court's analysis in Smith v. Kane, for example, the Supreme Court observed that evidence impeaching an eyewitness may not be material if the state's other evidence is strong enough to sustain confidence in the verdict. That is essentially what the appellate court was articulating in this case.
Can I ask you what just seems to be the hardest thing about this for me?
Sure.
If I'm the defense attorney at trial, or if I'm the government at trial, this testimony from this former significant other of his, I think, this seems horrendously bad for him. This testimony of like, I saw him researching silencers, that's really, really, really bad. And I guess it seems difficult. I don't know if it's unreasonable under EDPA, but it seems difficult for me to argue that impeaching a witness who provided what in some ways is the most devastatingly awful testimony against my client isn't material. That seems, like when they say like she's not a critical witness, I'm like, really? She seems like a really important witness to me.
I think she's certainly a key witness, but I think what Your Honor has articulated is fair-minded disagreement. The appellate court was reasonable in weighing the remaining evidence, assuming that the jury would have totally discredited her testimony. And certainly she was a key part of the state's case. But the state court was not objectively unreasonable at looking at all of the other overwhelming evidence.
Really? Without her? It's overwhelming?
I think Michael Bradley's testimony, for example, is very compelling. I mean, he essentially established that Mr. Martin was up in Maggie McFadden's bedroom taping together the silencer. We have other evidence, including the DNA evidence.
I mean, given the disagreement you have with the district court and the appellate court, like, can we agree at minimum that that testimony could have been clearer? Because I have to say I've read that testimony again and again and again, and I'm actually kind of having a hard time figuring out what exactly he's testifying to happened.
Michael Bradley's testimony?
Yes.
Sure.
Like, who's where, and who are we talking about now, and when am I talking about me, and when am I talking about her, and when am I talking about the defendant? His testimony, at least when you're reading a transcript, it is not always super clear who's doing what where.
I think that if a careful reading, the court would find that Michael Bradley was testifying that Frank Bradley brought the tape to the kitchen where Martin was, that Martin and Frank then went upstairs to the bedroom with the tape. Bradley came back downstairs, got the bottle, and went back upstairs to where Martin was with the bottle. And that is where the bottle of silencer was constructed.
Who had the tape? Who did he say he saw with the tape?
He said that he saw Frank with the tape.
Frank with the tape.
Frank Bradley, and he brought the tape to
And
the
he,
kitchen.
who is he? Who's
Frank
he?
Bradley
Yeah,
brought-
Frank. Okay,
Yes.
everything is Frank. Saw Frank. Frank brought the tape, and go ahead.
Frank Bradley brought the tape to the kitchen,
All right.
and then they asked him where he went with the tape. And he said that Martin went upstairs. Martin went upstairs.
He didn't say Martin went upstairs with the tape.
He did not say with the tape. He
Yes,
said
exactly, he
that Frank
didn't.
Bradley went to the kitchen with the tape, and then they both went upstairs.
Right. No one testified that they saw him with the tape. As a matter of fact, in the tape that was consistent with the tape that was on the Gatorade, whose house was that found in?
The tape was in Maggie McFadden's house.
And Maggie, is that a sister or some of the witnesses?
The sister. That
Sister, right? You know the record.
sister of I think the Bradleys.
Bradley, right? And did he testify that he testified because of she was a suspect? That's what did he say that?
Did Michael Bradley
Was there testimony
testify?
like that in this case?
I don't think that she was ever seriously
I
considered.
didn't ask you, was she? I said, did he testify to that?
He testified because I think
Did he say that it was related to her, his testimony?
Yes, he testified that if I recall correctly, he testified that Martin was threatening Maggie and she asked him to testify.
Oh,
She
he didn't-
asked him
he didn't
to cooperate because
I'm
Martin.
gonna hold you to this. You're saying that he didn't say anything about that he was testifying related to, she wanted him to testify.
Yeah, I agree with Your Honor. Yeah,
And
he
because-
testified that he cooperated with the police because Maggie asked him to, because Mr. Martin was threatening her.
And not because that she was a suspect at all.
That I do not. I don't believe so. If Your Honor has
No,
some,
I'm just asking I'm asking you the question.
I recall from the testimony that he testified that he
But see,
cooperating.
this is the strong case you're talking about that Judge Hyden just asked you about. I mean, even you up and down with the record, the witness she was a key witness, matter of fact, didn't he say that this is the person that you can really believe, and he propped her up with the jury in closing arguments in that sense? Correct?
Yes.
But
certainly.
the authorities knew very well that they had the computer that she identified specifically as being the property of the university, correct, at the time?
I would agree that the authorities certainly knew they had a computer. Whether or not that's the computer is still a question, but certainly they had a computer.
Wait, can I ask you about that? Judge Gregory,
Yeah.
are you on the line?
Go ahead.
So this whole "is this the same computer" question has vexed me and perplexed me. And I think, let me just posit by saying, I think there's a plausible argument you can make that maybe it's not the same computer, but I don't know what to do with the fact that in footnote 6, the state appellate court, whose decision we're giving extreme deference under AEDPA, said, we are assuming it's the same computer. So it seems to me that as a habeas court, we have to take the state court's word for, I feel like in habeas cases, the state tells me over and over again, I'm not allowed to second guess the state court, but here the state is trying to get me to second guess the state court. The state court decided this case on the premise that these are the same computer. So I think as a habeas court, we have to assume they're the same computer, notwithstanding your belief that maybe they're not the same computer.
I'd love to clarify. So, yes, I absolutely agree with everything you said. As the court, I'm sure, is well aware, federal habeas is sort of a two-step process. Step one is reasonable deference under 2254. And certainly, it is our opinion that the appellate court's decision should be looked at exactly what it was, including that footnote, and it was not objectively unreasonable in that regard. Now, with respect to if the court, in the event that the court decides that the state court's decision is objectively unreasonable, which we don't think the court should, then the court proceeds to de novo review. And under de novo review, the court looks at the entire record and can make a different decision about the weight of the impeachment evidence.
What's your best authority for that? I mean this sincerely. I'm not aware of a case where a federal habeas court does that. Goes like, so I read what the state court says, and I gave deference to all the factual findings I need to give deference to, and I did all that. And having done that, I've concluded they meet the extraordinarily high AEDPA standard. Cool. But instead of granting a writ, I'm not going to start over and make my own decision, including reassessing all the facts. What is your best authority for the proposition? That's how federal habeas review works.
I do not have a case off the top of my head.
I've never seen a federal habeas court do that.
I assure the court, and I'd be more than happy to submit a supplement to demonstrate to the court that certainly there's a
Wow, that's an even more heads I win, tails you lose than I would normally associate with AEDPA. That you give super deference to the state court. If you conclude the state court is so wrong that it satisfies AEDPA, the state then gets another chance to win.
That's the test, yes. The court will then proceed to de novo review and review the claim before.
I would think that if we conclude 2254 is satisfied, we just affirm the grant of habeas relief.
If the court concludes that the state court's decision is objectively unreasonable.
Contrary to or an unreasonable application of clearly established federal laws declared by the Supreme Court of the United States, if we conclude all that, don't you just...
It strips the state court's decision of deference. But then, yes, this court would then proceed to de novo review and reconsider the claim.
And then we can consider your argument that it's not the same computer after all?
Absolutely. Absolutely. The state court, as I argued earlier, was correct to assess materiality by weighing the remaining evidence to determine whether there's a reasonable probability of a different outcome. And I want to sort of move on in the last few minutes I have to what the district court, we think, got wrong in this case. And the first and I think most concerning aspect of the district court's decision was that it concluded that the Gatorade bottle, without Sherry Carter's testimony, was simply a Gatorade bottle. And we submit to the court that couldn't be further from the truth. Just simply looking at the photographs of the bottle we have submitted to the court, you can see that clearly it was made for a specific purpose. The record supports that this was a bottle silencer. That is what the jury would have inferred. And the appellate
Can we
court of
probably agree
Maryland-
the state could have prevented better testimony that this was a bottle silencer? Like, we've got like one guy saying, I saw a Steven Seagal movie. Like, it feels like this is something that could have just been nailed down a little more. Don't you think?
I do not disagree that, in the better situation, we could have had a better record, but we are stuck with the record that we have. But ultimately, the question is, again, whether the state court's assessment of the record was objectively unreasonable.
But counsel, you chuckle, I understand that, but these are serious matters. I mean, the most important thing you have as a human being, as a citizen, is your liberty in terms of your person, your freedom. You're talking about a serious case here. And you saying, again, as Judge Hayden said, a movie, it looks like something I saw in a movie. It isn't very scientific. But why wouldn't you test the dark powder to see whether that was even gunpowder?
I think that the detective, I think he was the lead detective, testified, or maybe it was the evidence handler. They weren't concerned about what had happened. They assumed they found the bottle next to a shooting. They weren't really concerned about what it was for, but rather who it was connected to. So they didn't test it for gunshot residue. They tested it for DNA in order to determine who committed the crime and not necessarily what the purpose of the bottle was for.
Well, you knew enough. You had a so-called expert to say that the Gatorade bottle was consistent with being a silencer. You thought that was important, but not enough that whether or not, in fact, this was gunpowder, it was actually used for that purpose. Let me get back to this. I mean, I practiced law for 20 years and did a lot of criminal defense work. In this case, the jury instruction given was devastating. Devastating. You can use this evidence that's intentional to destroying, doing away with evidence, and that can be used for the purpose of finding guilt. How do you just take that and say, well, because all of that, you would have gotten the jury instruction on that if she hadn't testified to that, and you take that away and you say that that's not an incredible impact on this case?
That is what the appellate court found.
That's what they said, but that's unreasonable for anybody to really to tried any cases before, any criminal cases. That is the most devastating one you can have.
I disagree that is an objectively unreasonable application of Brady. That this
How important do you think that instruction is in terms of devastating to the defendant? Do you appreciate that that's very devastating?
I appreciate that it certainly chips away at the strength of the state's case. But
Chips away.
yes, Your Honor. But there's the DNA evidence. You have the
DNA
bottle silencer.
The DNA evidence, for example, they said, on witness that he's the one that the Gatorade that he drinks from it.
I'm sorry?
He drinks Gatorade.
Yeah, I do.
What then his DNA would be in a Gatorade bottle that could be used later for somebody else to have a silencer. How is that conclusive?
They also found his DNA on a piece of, in a hair follicle that was attached to the tape that was wrapped around the bottle. On top of the fact, again, you have Michael Bradley's testimony suggesting that Mr. Martin was, in fact, the one who
You
assembled
had two
the bottle.
other items of evidence on that bottle, too. The bottle was found at the scene of the murder, not at his house.
Absolutely.
And you had the notion that the tape was shaped like the barrel of a gun.
Also
And
true.
then you had the hole in the bottom of the gun being from inside out, being created from inside out as opposed to being punched in.
Also true. And on top of that, you have the detective's testimony suggesting that it, in fact, appeared to him to be a silencer based
Could I go
on-
back and ask the sort of factual premise about something Judge Gregory was asking about? Do you agree that if we have to assume the jury would have totally discredited this witness's testimony, at that point, do you agree there is no legal basis for giving this consciousness of guilt instruction?
Assuming that her testimony was totally discredited, would the court would not give I think the court would not have given that instruction.
Wait, is that a predictive matter or that the court would have no legal basis for giving it?
I think it would depend on how the impeachment turned out.
Let me rephrase. Do we need to
Yes.
assume, for purposes of the Brady analysis, that instruction shouldn't have been given?
In terms of EDPA deference, yes, I think that the appellate court concluded that the jury instruction likely would not have been given, and it factored that into its analysis and concluded that nevertheless, it was not objective, or nevertheless, the petitioner failed to meet his burden to demonstrate materiality. And again, we argue that that is not an objectively unreasonable assessment of the case.
Can I ask one other question? Judge, on remedy, I understand that you don't like the fact the district court only gave you 60 days. Have you been able to identify a single case where an appellate court reversed a district court that only gave 60 days to retry someone?
I do not have a specific case where it was reversed.
All right, thank you, Mr.
Thank you.
Maselli. All right, Mrs. Walend.
Good morning, Your Honors, and may it please the Court. Nicole Whelan on behalf of appellee Charles Brandon Martin. Mr. Martin was convicted of attempted murder as an accessory before the fact based on circumstantial evidence.
You want to keep your voice up a little bit?
Yes, sir.
Thank you.
In an extremely close case, the jury rejected part of the state's theory. It acquitted Mr. Martin of solicitation to commit murder. Had the computer report been properly disclosed, there is a reasonable probability that at least one juror would have had reasonable doubt as to Mr. Martin's guilt as an accessory before the fact as well. Sherry Carter's testimony was the linchpin of the state's case. She testified that she saw Mr. Martin looking up gun silencers on the computer. According to Ms. Carter, Mr. Martin told her that silencers were illegal and only police could buy them. She also testified that after the shooting, Mr. Martin took the computer, saying that he was going to get rid of it because he didn't want it searched because of the things that they had looked up. Carter's testimony formed the basis for the state's theory of intent. The prosecutions argued that Mr. Martin's planning it for a little while shows the intent to kill. Her testimony also provided the basis for concealment of evidence instruction on which the jury could infer guilt. And the prosecution urged the jury to do just that. It said that he got rid of the computer because there was probably something on it that would have brought the police's attention to the fact that he had something to do with this murder or attempted murder. And the prosecution highlighted Carter's particular credibility. It said that the things she said are very powerful, and she is someone who's very sane and very normal, but caught up in a bad situation. But the police never turned over a computer report that would have allowed the defense to impeach Ms. Carter's testimony. And had defense counsel been able to use the state's own forensic analysis, a reliable source, to impeach her testimony, the state's case would have crumbled because the state would have no longer had evidence connecting Mr. Martin to the bottle as a silencer or forming the basis for intent.
Can I ask you this? The state court gave you credit, assumed the exclusion of her testimony, and then reiterated in some detail the evidence that still remained in the case. And it seemed to me that somebody could disagree one way or the other whether that was enough, but it was quite a bit. They went on for quite a while. We don't see state court decisions that thorough on this kind of subject. And they went through all the evidence about the bottle, the DNA, the presence of the bottle there, the linkage of the bottle to Martin, and the fact that the bottle could not be used for, the hole was punched out as if the bullet was going through, and the barrel was shaped, the tape was shaped like the barrel of a gun, rectangular, so to speak, and had black soot inside. These things all indicated they were at the scene where the murder was. And there was also evidence that she didn't drink Gatorade, so that it came, but there's no question it was linked to Martin by a lot of evidence. And I don't know why we are in a position to go ahead and say that court got it all wrong. It seems to me this is a state process, and only if the state went off the deep end and didn't follow federal law or constitutional law do we reverse. But to me, they gave it a lot of attention. It's a hard thing to comply with EDPA and say the state, we disagree with the state. That is not the standard, whether we disagree. The standard is whether they got it so wrong that there really wasn't any ability to disagree.
This court's review under AEDPA is to look at whether it was contrary to or unreasonable application of clearly established federal law. And it was. The Court of Special Appeals didn't even consider the elements of accessory before the fact or how this evidence was the state's only presentation and closing argument as to why Mr. Martin had the requisite intent to be guilty. It also
So can I just posit, I think if but for EDPA, you have a spectacularly strong case, and my real question is just EDPA. So can I start with contrary to, because this is actually where I think you're weaker. I agree the state court occasionally said things that sound like weighing the sufficiency of the evidence. I will posit that that's true. I will also posit that the state court on multiple occasions recited the correct legal standard, including at the beginning and the end of its analysis. Doesn't the Supreme Court's decision in Woodford versus Viscotti just say in situations where states courts use loose language, we cannot assume they're contrary to? We have to give them the benefit of the doubt, and the benefit of the doubt is when they say the legal standard correctly sometimes and arguably say it incorrectly sometimes, we have to assume they were applying the correct legal standard. So doesn't that just dispose of any contrary to argument?
I don't think it disposes of the contrary to argument, Your Honor. I think that it was contrary to because the Court of Special Appeals did what the Kyle's court said that the dissent was doing. It just excluded the testimony. And we know that from JA 743 footnote 14, that's where the Court of Special Appeals is describing its analysis. It says, quote, it's excluding Ms. Carter's testimony. But that's not the complete Brady materiality analysis. It still has to look at how the impeachment and the computer report would have put the other evidence in a completely different light. It didn't do that. And I think that's seen particularly in looking at Michael's testimony. The state, my opposing counsel got up and called Michael's testimony very compelling. We know that that's not true because this Michael's testimony formed the basis of the state's theory of solicitation before the fact. The solicitation before the fact discussion, when it was in closing argument, the prosecution said that Gerald Burks was the shooter because he was with Martin the day of the shooting. They left together at the right time. They came back together at the right time. Burks was agitated. All of that comes directly from Michael's testimony. And so the acquittal on solicitation suggests that the jury already disbelieved Michael's testimony. And that makes good sense given the ways that Michael's testimony was incredible and already impeached. Michael had told Mr. Martin that had told police that Mr. Martin had been at the house all afternoon of the shooting. That was in the first police interview that was lost by the police. And then he only changed his testimony, and this goes to Judge Gregory's question to opposing counsel. He changed his testimony because Maggie McFadden told him that she was involved. That's at JA 2043. And the prosecution isn't accurately reporting the record when it says that the testimony was that Mr. Martin was threatening. The testimony suggests that the prosecution was the one that Ms. McFadden found threatening. Michael's testimony says, she says that they brought her here and he was threatening, suggesting that the people who brought her there, the prosecution was threatening. So Michael's testimony was already incredible. He was testifying because of his sister, who had access to the bottle and the tape that came from her house and was presented by the defense as an alternate suspect in the case. Michael had a prior conviction for obstruction for lying to police. He received 2 different benefits for his testimony, and even at trial, his testimony was confusing and inconsistent. He originally said that Frank and Mr. Martin had never spoken before, eventually, after prompting from the prosecution saying that they had in fact spoken, that Mr. Martin had given Frank a bag and saying to get rid of it. So we know that the Court of Special Appeals didn't properly credit the fact that Michael's testimony was already discredited and disbelieved by the jury on the solicitation count. And weak evidence becomes weaker if it's no longer corroborated. Without Ms. Carter's testimony tying the threads together, the state is left with Michael's already incredible testimony and DNA evidence.
So can I actually, so I've really struggled with this, like what conceptually under Brady do we do? Do we assume like she just doesn't testify? And that, I agree, there's language in Kyle's that suggests we do this broader thing that you're saying, but then what you were just saying pinged something, so I was just looking for it. I remember when I was reading the State Court of Appeals opinion, this is on JA 739, where they say the parties assert that the proper way to do the Brady analysis is to disregard the witness's testimony. That starts to sound like what they're doing is what the parties, and I assume you were not his lawyer before the Court of Special Appeals, but if we posit for the sake of argument that before the Court of Special Appeals, everyone was assuming that the way you do this is just disregard her testimony, but don't do this broader, what impact does it have on the state's case? What does that do?
Your Honor, I don't think the parties can change the legal analysis that the court is supposed to do. I think that,
But it's not contrary to or an unreasonable application of federal law to agree with to assume for the sake of argument that the parties' joint articulation of the legal standard is correct. How is that contrary to? I mean, courts constantly write opinions where they say things like, the parties agree that X is true about the law. We are not holding that X is true about the law, but nor are we interrogating that. We're deciding the case the way the parties frame it for us, right? Courts do that literally all the time.
sure, I certainly don't think that's what, looking at the briefing below, that's what was said.
Okay.
I think that that saying that they look at Ms. Carter's testimony excluded is part of the analysis. I think that you look to the fact that Ms. Carter.
Not that we conduct a case-specific analysis of how badly would she have been discredited. We just throw her whole testimony out.
Right, you consider, and that's, the court says that in Strickland, Strickler, that it's either severely impeached or excluded entirely. That's the Brady materiality analysis. I think that the parties, Mr. Martin's counsel below, it was clear that you do a full Brady analysis. You don't simply stop there. You still look at how the whole case would have been painted in a different light as Kyle's directs.
So can I move us to unreasonable application? What is your best case? Is it I assume it's Kyle's?
Yes, I think Kyle's is the most obviously on point case. It has a discussion of where eyewitness testimony is critical and that testimony is impeached. Here we know that Ms. Carter's testimony was critical because she was part of the testimony for intent. She tied the threads together. Kyle's directs that we look at the likely damage of the case by looking at the word of the prosecutor. Here we have what the prosecutor said in closing argument, which was how credible she was. It was urging the jury to adopt the consciousness of guilt based on the concealment of evidence instruction. It provided the evidence, it cited to Ms. Carter's testimony as evidence of intent. And Kyle's also makes clear that not every piece of evidence has to be undercut for evidence to material.
But I can just cards on the table. My biggest concern about Kyle's, in Kyle's, there's multiple pieces of suppressed evidence, and the court goes through those multiple pieces. And again, let's posit for the sake of argument that if we're not in EDPA land, I think you've got a really, really strong argument. But why isn't that enough to say that it's not an unreasonable application of Kyle's? Because Kyle's involves multiple pieces of evidence and more extensive and significant suppression than we have here.
I don't think that Kyle's turns on the fact that there are multiple pieces of evidence, and I don't think that is required in order for a case to be an unreasonable application of clearly established Supreme Court law. I think there are cases that that this court has held are unreasonable applications that don't.
Which we, in this bizarre world of EDPA, have to pretend don't exist, right?
I think yes and no, Your Honor. I think that those cases, as applying the 2254 D1 standard, are helpful because they look to how this court has already articulated clearly established Supreme Court law. We're not looking to them for having created more law, just that they're illustrative of what is clearly established.
So what we can't say is this violates clearly established federal law because here's another case where we held this violates the Brady. We can't do that. That's the thing EDPA says we can't do.
Yes, Your Honor, but I think you can say that it's clearly established and look to those cases as to exploring what has already been clearly established by other panels. And I think I do want to turn briefly to the DNA evidence because opposing counsel in the reply brief spends a lot of time trying to explain how Ms. Turok's DNA or DNA consistent with Ms. Turok's could be on the bottle. I think that just demonstrates that there are innocent explanations for how DNA can get on a movable object at a crime scene. There are innocent explanations for how DNA consistent with Mr. Martin's is at the crime scene. And without Ms. Carter's testimony to point to the bottle as a silencer and that Mr. Martin had been researching silencers, those innocent explanations become more persuasive to the jury.
Can I ask you about something factually that I didn't see addressed in your brief? The whole, this could have been a bong. What do we do with the detective's testimony that I smelled this and it didn't smell like marijuana? Isn't that pretty bad for this could have been a bong?
I don't think it is pretty bad, Your Honor. I think that there's no testing of the bottle to know what the substance was. It could have been used a lot earlier and the smell could have dissipated. We simply don't know, and it's the prosecution's burden to prove that it was a silencer. And I do want to point out that the...
How do you point out the other evidence about the bottle? For instance, the shape of the tape, like the barrel of a gun, which doesn't fit any other hypothesis, and then the fact that the hole in the bottom of the bottle was created by an object going from inside out, not being punched in. And wasn't there testimony that, did somebody give an opinion that that was a silencer?
No one gave an opinion that it was a silencer, Your Honor. The sergeant who testified that he noticed the bottle at the crime scene during his walkthrough because it reminded him of a movie silencer. Not that he testified that it was his opinion, that it was a silencer. No one even provided an expert opinion that Gatorade bottles could be used as silencers. And the statement that it was punched out, not in, came from the prosecution in closing. That wasn't evidence in the record. The bottle was in the record.
I looked at the bottle picture. I mean, it's obvious it's punched out. All you have to do is look at the picture. There's 2 or 3 pictures in there.
I think the jury could have looked at it and come to a variety of conclusions, Your Honor, but there wasn't evidence that what the characteristics of a bottle silencer are, how bottle silencers are formed, how they're used.
I understand that, but the fact that this was pushed out, this all was overlooked by the district court. The fact that the tape was shaped like the barrel of a gun, it was rectangular or 2 parallel sides, and that there was a dark color inside that didn't smell like marijuana, and there was a hole punched out, and it was shown on the picture of the bottle. You can see the plastic pushing out in the evidence. This is all pretty inconsistent with the notion that it's some kind of smoking device.
I don't know that it's inconsistent, Your Honor. I think that the prosecution had to prove that it was inconsistent, and I don't think that they did that. But even if the prosecution had proved that it was a silencer, the prosecution still had to prove that Mr. Martin was the responsible party for constructing the silencer. And without Ms. Carter's testimony,
Well, they had that hair on the tape, and they had two aspects of DNA linked to him.
they had hair on
And
the...
they had the bottle, they had evidence of the tape, and they had the evidence of Bradley and Martin going upstairs and doing something with that tape and with a bottle.
They had hair on the tape. They also had a cat hair on the tape as well, and their own technician testified that hairs can be in the environment for up to a week, and then we shed 100 hairs a day. So the fact
The
that...
whole thing is a common sense thing, you know. The fact that there's a cat hair on there, what's that got to do with it? I mean, sure, that's important because it shows that they went in detail to examine it. But the affirmative evidence, when you shoot from so many angles at a particular point, it gets to a point where there's no doubt of what's going on.
I think the cat hair is important because it shows that there are innocent explanations for hairs being on tape that aren't the only reason that the hair is on the tape is because that person constructed the bottle. And the fact that it was found...
It's not the only reason. The fact is that he drank Gatorade, they went up, Bradley and Martin put this thing together, it appears at the scene.
Well, Your Honor, there's not evidence that it's the same bottle that Michael testified to that was at the scene. In fact, there's...
If it's not the same bottle, then how's it DNA? And she didn't drink Gatorade at the house. It was at the murder scene lying on the floor there.
Well, Ms. Turok, their DNA consistent with Ms. Turok's is found on the bottle, and the state's theory can't explain that if the bottle came from Ms. McFadden's house. Frank's DNA isn't on the bottle, and the state's theory is that Frank heavily handled the bottle. He's the only person who the bottle is ever in someone's hands in Michael's testimony. So the state's theory isn't consistent with the DNA evidence because it can't explain the presence of Ms. Turok's DNA to the extent that it's hers, and the same way to the extent that the DNA on the bottle is Mr. Martin's, and it can't explain the absence of Frank's DNA.
Can I ask you on the, so there's sort of two arguments you pursue factually in the brief. One is maybe this isn't a silencer, and maybe it's not connected to my client. But the thing I'm just trying to conceptually struggle with, let's assume for purposes of this question that the jury finds it is a silencer. What is the innocent explanation where it is a silencer, but it's not connected to the defendant? Like, what is the factual scenario that? So you need to posit that this is a silencer.
I think the factual scenario for that is that someone at Miss McFadden's house had access to a bottle that Mr. Martin drank from. Any number of people could have had access to it, given the testimony that Mr. Martin drank quite a bit of Gatorade. And so Michael Bradley had access to it. Frank Bradley had access to it. The third brother, Dennis, was also at home. Perhaps it was constructed at a different time, and McFadden had access to it. So and there are any number of people who may have had access to a bottle that Mr. Martin had drunk from.
So just to clarify so none of these involve a completely unrelated individual who has no connection to the defendant constructed the silencer. It would have to be someone who was in and around the defendant constructed the silencer.
I think that it's plausible that someone unconnected constructed it, but assuming that because the DNA was consistent with DNA with Mr. Martin's and DNA with Mr. Rock's, it would make the most sense that it would be someone who was in and out of the home. And Michael testified to the fact that there were a number of other men who were in and out of the home. Mr. Rock was dating someone who similarly was unhappy with her pregnancy. So there were a variety of people who may have had access to a bottle that both Mr. Martin and Mr. Rock drank from. I see my time is up. Thank you.
Yes. Mr. DiMaselli?
Thank you, Your Honors. A few points. My opposing counsel suggested that Sherry Carter's testimony was the linchpin of the state's case, and that without her testimony, the state's case would have crumbled. We vigorously disagree. We think the appellate court assessed the record correctly and properly relied on Michael Bradley's testimony, the DNA evidence on the bottle, Martin's ownership of a .380 caliber handgun, Martin's comment to Frank Bradley to get rid of a paper bag shortly after the shooting, Martin's false alibi that he gave to the police, and of course the evidence of the motive to commit the shooting in the first place. So as Judge Niemeyer pointed out, there is no question that this bottle was linked to Mr. Martin. I think that there's also no question that this bottle was in fact a silencer, and that's what it was constructed for, that's what it was used for. Absolutely, the hole was punched out. You can see that in the photographic evidence. The bottle itself was admitted into evidence and provided to the jury. The prosecutor asked the jury in closing argument to find that that object was in fact a silencer, and based on the jury's ability to look at the physical characteristics of the bottle, they certainly would have concluded that that was, in fact, a silencer. There's a mention about the
Could I ask you to address the thing that your friend on the other side said at the very end? So let's posit this is a silencer. Let's posit that the witness in question doesn't testify. Let's posit that the consciousness of guilt instruction is not given. Why isn't there a reasonable probability that a jury could credit the defense, like fines, like you heard her explanation that posits that it's a silencer, that nonetheless is somebody else did this. Why isn't it reasonably possible that a jury could have credited that explanation if, again, we assume that this devastatingly bad testimony, I saw the defendant researching silencers, is out?
Well, I think Your Honor actually articulated it quite well in that this bottle had to have been related to somebody. Clearly the bottle came from
Yeah, sure, but it's the woman who owns the apartment. It's the other guy in the apartment, many of whom are mad at the victim.
Well, I think you start from there and then you begin to parse it down. Then you have the DNA evidence. And I wanted to make that point.
Sure, he drinks Gatorade. That's where the DNA comes from.
But he has his hair follicle attached to the inside of the tape wrapped around the neck of the bottle. And then the bottle just happens to appear just several hours later at the crime scene. So it narrows the possible scope of the shooters and the people involved in this case.
It was his gun involved.
Presumably it was.
No, there's no evidence that.
There's no other gun. The others don't have that gun, right?
That I think Your
Counsel,
Honor,
you said there's no evidence that was his gun.
there's no evidence.
Well, we'll tell the truth, but in terms of fact of it is he has a gun that's similar, correct?
That's absolutely
There's
correct.
no evidence
They never found the murder weapon.
Thank
or
you.
the
I just-
attempted murder
okay.
weapon.
But that's the whole problem with this. The whole thing about this is just incredible, that it's in the disjunctive. All resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented at trial. That's the question. Here, I mean, it's just incredible to say that this was not devastating in terms of, that was the key to the silencer. 1, 2, 3 people could have been connected to the silencer, right? Even if that's positive, as Judge Hyden said, positive there was a silencer. Which one do you pick? Oh, this is the only person who researched silencer. What was the jury to do but to say, it's you, buddy? I mean, that's common sense. Did we lose our common sense in these cases? That's what the federal district court was looking at. Someone who sees trials and look at those, it's amazing to say that's not an unreasonable conclusion.
The state court put stock into the other evidence in this case,
But the
including
evidence
the
was
DNA
frail.
evidence.
It was frail. You can tell by the summary. The summation was, this woman here, you can believe her. Unlike these other people, maybe a little checkered. I mean, I'm just paraphrasing. But this person, they buoyed her on an issue that was devastating to him and told the jury, you can assume that he did it if you believe he destroyed it, like she said he did. And you said that's a reasonable conclusion to say, it wouldn't have made any difference. I don't see how you could do that in the sense of having any sense of trying cases in terms of a criminal case and having it. I don't understand that.
Judge Niemeyer said it, that there's no question that this bottle is linked to Mr. Martin. There's the DNA evidence.
Yes,
they
it
have
could have
him
been
in the
linked to
room.
him. You're right, it could have been linked to him, but it could have been linked to other people. But she brought home the thing. It's the person is to bring home the bacon. The bacon was, yes, he's the one sitting there saying, listen, I'm going to destroy this thing. I'm going to take this thing away. What would the jury do? Say, he took it away and he's destroyed the computer. Nobody else did that, so must be you. I mean, you'd have to just ignore every sense of common sense to say that wasn't devastating.
I disagree. I think, again, the state court was not.
Maybe it's just me. Maybe it's just me. Maybe I'm like this federal district court judge. I just try to think that the great writ means something, even though EPA says it's there and Congress didn't. But it was found to be constitutional because they said that still the great writ exists. I don't see how the great writ exists in terms of habeas and these facts like this that said this was not an unreasonable determination of fact. But go ahead.
I see I'm out of time. Does the court have any other questions?
Thank you very much.
Thank you so much.
We'll come down and greet counsel and take a short recess.
Now the court will take a brief recess.
hear from you.
Good morning, Your Honors. May it please the Court, Shai Dvoretsky on behalf of the appellants. I'd like to focus this morning on two issues from the briefing. First, as to contract formation, Gordon entered into an arbitration agreement when he signed into the website and clicked agree after being presented with terms and conditions on the pop-up. I know the Court has asked the parties today to address the Marshall case, so I'd like to discuss why that case supports our position here. Second, I'd also like to address why plaintiffs are bound by that arbitration agreement as a matter of agency law, because here, as in the Fifth Circuit's recent decision in Jackson versus WWE, Gordon acted as plaintiff's agent when the plaintiffs allowed him to show their tickets in order to be admitted to the stadium.
Let me get to the nub of what gives me pause in this case and difficulty. This is a motion to compel, and it was treated as a motion for summary judgment, which is a motion usually filed in context of where there's a potential jury trial. Motions to compel, I believe, are tried by the court, just like transfer motions, jurisdictional motions, and the courts find the facts on that. And so it seemed to me it got the district court off on the left foot by filing a motion for summary judgment. The court should have resolved the facts. And I'll tell you what my factual problem is, and maybe you can help me. As I understand it, when Gordon went to get the tickets, he is led into Ticketmaster site. Ticketmaster site clearly indicates it's functioning to take care of tickets for Commander football games. You go into that site, and if you credit your man's affidavit, you have to type in your password and your ID, and then you get to the site, and then you hit a bar, and it pops up terms and conditions with the arbitration agreement in it. That seems to be sufficient under Marshall for a contract with Ticketmaster, limited and with a plan. With an arbitration clause. But then to get the ticket, you go further, and then the tickets appear with a code on them. You see the actual picture of the tickets. And for the terms and conditions of the tickets themselves, it has the 3 dots in the corner that you have to click to go to the back of the ticket. Now, if I assume that the terms and conditions that piped up first were Ticketmaster's terms and conditions, and that the terms and conditions for the ticket, as the Commanders and the football teams, terms and conditions were on the back of the ticket, and you had to click those 3 dots, I'm not sure, under our Marshall opinion, that the second aspect, there was contract formation with the Commanders. Now, so it's a complex question because I'm not sure what the facts are. The plaintiffs come in and they say they never saw any terms and conditions, but it seems to me your man demonstrated that if you go into Ticketmaster, you automatically get into it. You can't get past them. But those are Ticketmaster's terms and conditions, and so now, and not only terms and conditions, it may not be enough because arbitration clauses have to be highlighted. So you have to be an indication there's an arbitration clause. My whole question comes into contract formation under Maryland law. And the Marshall opinion that we issued very recently and have alerted you to addresses that in some respect. And based on what your facts are, it seems to me, and I'll just tentatively, this is very tentative, I haven't reached any conclusions, except that the court should have resolved these facts. I think the district court should have resolved those facts, and maybe the right approach is to send it back and let them resolve those facts. But let's assume the facts are as I say. Then it sounds to me like Ticketmaster had an arbitration clause. The Commanders and the stadium did not have a arbitration clause under Marshall. I don't know if you understand where I'm coming from on that, but if you can address that and help me out on that, that would be terrific. That would advance at least my understanding.
So, Judge Niemeyer, let me make 2 points in response to that. First, if the court does think that there are factual disputes that the district court didn't properly resolve, the appropriate course here would be to vacate and remand for limited discovery.
I understand, and I'm suggesting to you that may be the appropriate course after we get done today talking with both counsel. But my whole point on that is a very fundamental procedural point. This is not a summary judgment context. This is a motion to compel arbitration, and the court should have resolved facts. Even though, and if those facts have not been resolved, maybe we need them to be resolved before we can answer the questions. On the other hand, maybe we don't, because the motion to compel requires your demonstrating that there was a contract. And the question is, maybe you were insufficient on that. So, but the whole context is highlighted by this different steps in getting the tickets. And of course, clearly, Ticketmaster is the gate to get to the Commander's tickets. And the Commander's tickets do have terms and conditions on the back, which have the arbitration clause. But to get to that, you have to hit one of those three. You have to hit those 3 dots in the upper right corner.
So, Judge Niemeyer, I think that last part of your question, that in order to get to the Washington Commanders' terms and conditions, you have to click on the 3 dots, that's not correct under this record. We don't need to rely on the 3 dots in order for there to be a contract with the Commanders. The contract with the Commanders is formed as a result of the first 2 steps of the process.
Yeah,
but
you're missing my problem. You can argue that the Ticketmaster terms and conditions apply to the Commanders. I'm not sure that's so. In other words, when you go through the terms and conditions that include the arbitration, you're still on the Ticketmaster site. And you have to open up with your identification and your password on the Ticketmaster site to get on. And then the very first thing, there's a bar you hit. And according to your evidence, at that point, terms and conditions pop up. Those terms and conditions, though, are on the Ticketmaster site. They then give you the tickets after you go through that. And on the back of the tickets are the Commander's terms and conditions. You're assuming that that pop-up is the Commander's terms and conditions, and I'm not sure that's so.
Well, the pop-up that we're talking about appears on Joint Appendix 186.
I've read it. I've seen it, but it comes right after you hit that bar at the bottom. You have to go through it to get to the tickets.
So you don't actually have to go through it, because even if you don't sign in, on Joint Appendix 185, which is that sign-in screen, you can click on a hyperlink for terms of use. And the terms of use would bring up that very same pop-up that comes up after you sign in. And when you do then get that pop-up window, it's showing both the Ticketmaster site, Ticketmaster terms.
Who's going to go terms of use? I mean, in other words, Marshall requires, we're talking about the formation of contracts, mutuality of the parties. And the idea has to be, there has to be some method by which the user, the purchaser of the tickets, is directed fairly directly to, under Marshall, to the terms and conditions, which include the arbitration clause.
Completely agree. Marshall says that courts find that when a website provides clear and reasonably conspicuous notice that there are contract terms available by scrolling down or clicking a hyperlink, the user is on reasonable notice of those terms, even if she never reads them. That's Marshall at 220. The sign-in screen here clearly alerted reasonable users to the existence of terms of use.
Which page are you on?
Of Marshall 220.
Pardon me?
What page of Marshall, Your Honor?
What are you referring to? What page of the JA?
Joint Appendix 185 is where the sign-in screen is. And that sign-in screen clearly alerts reasonable users to the existence of terms of use. It makes clear that they were available by clicking the phrase terms of use, and it told users that signing in meant agreeing to those terms. A user couldn't click sign in without seeing that notice and having that opportunity
That is a notice, but then that takes you to the terms and conditions that I understand pop up. I'm looking at 148. Well, no, that doesn't help.
I think the terms and conditions that you want to look at, Judge Niemeyer, are at 186. And that's a pop-up window then. The sole purpose of that pop-up window is to display the terms of use.
All right, now in 184, when you go onto Ticketmaster and you type in, on Ticketmaster, it requires you have to have an account. And you have to have an identification and a password on Ticketmaster, right?
That's correct.
All right. Now, that particular sign is on page 148. And it tells you exactly what to do, right? It tells you to sign in to Ticketmaster
So
with your email, Ticketmaster email and password. And when you sign into Ticketmaster, you get 184, right?
So, Judge Niemeyer, let me correct another factual, perhaps wrinkle in this case. What you're looking at, Joint Appendix 1848, is a site for how to accept a transfer of tickets. The plaintiffs in this case are no longer arguing that the tickets were transferred to them pursuant to this.
I understand, but they go, in order to get the tickets, they have to go through the Ticketmaster site, right?
Well, their current theory is that Gordon bought the tickets and that he bought the tickets through a third-party site called TickPick, I believe it was called.
I understand, but you're avoiding my question.
I'm not trying to.
184, is that a Ticketmaster site? It says powered by Ticketmaster.
Washington, yes, it is a Ticketmaster Washington
Okay.
football team site.
So now what pops up on that page is 185, right?
Correct.
And then you say sign in, and you need to put an email and a password, right?
Correct.
And the email and password are for the Ticketmaster account.
Yes.
All right, so you punch in 185, and what pops up is the next page, 186.
Yes.
Those are the terms and conditions that pop up when you're in the Ticketmaster site. But then when you go further, after that, it says, you agree, then you get to the ticket. And the ticket is on page 195, right?
Yes.
And the upper right-hand corner of the ticket, there are 3 dots. And then on the back of when you hit those 3 dots, 196 and 197 pop up, right?
Yes.
All right. My question now, it's still not totally clear, but my question is, it looks like you're going through 2 sites. You're going through Ticketmaster site to get to the Washington Commanders tickets, and then the tickets themselves have the terms and conditions on back. And the question is, which terms and conditions are applicable to which company? And I think that first one on page 186 is on the Ticketmaster site.
So, but Judge Niemeyer, on 186, there are the 2 tabs. There's the Ticketmaster tab there, and there's the Washington Commanders Terms and Conditions tab. The Washington Commanders Terms and Conditions tab, which you have to agree to in order to get past this terms of use screen, those are the same terms and conditions that appear with the 3 dots on the back of the ticket. And so
What comes before that page, 186? How do you get to 186? Is it type into 185?
You get to 186 from 185, and you can get there one of 2 ways. You can either get there by signing in on 185, in which case you get that pop-up, or you can get there before even signing in by clicking on the hyperlink for terms of use on 185, and that will bring up the same pop-up. Either way, what you're getting there on 186 is a
Well,
pop-up.
stop on 185. Tell me what the options are there.
So on 185, it's telling you, by continuing past this page, you agree to the terms of use. And you see there how terms of use is highlighted in bold red font? You can click on that terms of use before you ever sign in. You can click on that hyperlink, and it will bring up what's on 186 so that you can see the...
That says nothing about an arbitration clause.
I'm sorry?
That says nothing about an arbitration clause. It's just terms of use, right?
It says terms of use, but then when you bring up the terms of use, if you look at 186, the arbitration clause is right there on that first screen in all caps, bold, underlined. So
What is the next, it's very hard to read this. It says privacy policy of the commanders, is that what it is?
no, but 2 lines up from that. By continuing past this page, you agree to the terms of use. You see what I'm referring to
Yeah,
there,
I do.
Judge Niemeyer? So, and then if you click on terms of use, that brings up what you see on 186.
Yeah.
It brings up that terms of use screen with two different sets of conditions, which makes perfect sense. You're buying a ticket through Ticketmaster for a Commanders game. So you've got the Ticketmaster terms of use. You also have the Washington Commanders terms and conditions. You're agreeing to both when you then click agree at the bottom of that terms of use screen. And that's what forms the arbitration agreement between Gordon and the Commanders before ever getting to the back of the ticket and the three dots on 195, 196. And under the Marshall case, that's sufficient to establish both notice and assent.
Notice and assent to Gordon, right?
Notice and assent as to Gordon.
Okay,
Right,
so,
that's-
because everything we've said so far may or may not be an argument for why you can make Gordon arbitrate, but doesn't address the district court's reason that you can't make the fans arbitrate, right?
Right, so that then takes us to agency law if the court would like us to turn to that.
Right. Could I ask just as a factual question, as a prelude to that, could you ask me, is there any evidence in the record that you offered that the fans asked Gordon to buy them the tickets before he bought them? Is there any evidence in the record to support that assertion?
I don't believe that there is evidence on that.
And who has the burden of a motion to compel?
Well, we would have the burden, but we don't need to rely on that. There was no evidence of that in the WWE case either. The tickets there were a surprise gift. Even so, the Fifth Circuit there held that by having somebody else swipe them into the event, they were giving the agent in that case was, the principal in that case was giving the agent the apparent authority to bind them to terms and conditions, including an arbitration clause.
But that presupposes that the principal had authority to do it, right? Yeah, but I realize we start to circle back around.
It presupposes that the principal entered into an agreement.
Right, the WWE case assumes that, right? The WWE case assumes that there was adequate notice to the principal. I think there's a footnote that says everybody agrees in this case there was adequate notice to the principal.
Right, I don't think it was disputed. I don't think it can be reasonably disputed here in light of this very standard chain of ticketing events that we have.
Well,
And so
it may not be that standard. Let's just go back briefly. I don't want to preempt Judge Hyten's question here at all. I just wanted to finish a little bit.
Sure.
He went on a site called what?
I believe it was TickPick.
TickPick, okay. Now, he says he went on to TickPick. The question is, could TickPick take him directly to the tickets?
So
Could TickPick have gone through this mechanism, for instance, going on these pages 184, 85, could it have been that TickPick went through these pages and got the tickets and then transferred them to his account?
No, what happened is that after he bought the tickets, he then received a confirmation email from TickPick and an email from the Washington football team ticket office with a link to accept the tickets. And in order to accept those tickets, he needed to go through the sequence we've been talking about.
Now, he says he went the way he went. He didn't see any terms and conditions. That's what he says, right? In his affidavit.
Well, it's also undisputed, though, that
No, just answer my question. Didn't he say that in the record?
I believe he says that, but it's also undisputed that he accepted or agreed to the terms and conditions that are on Joint Appendix 186.
Show me that. Where his affidavit is where?
I believe that
His affidavit is on 135 to 137. Does he say anywhere that he,
well, I think the key point, though, is not his affidavit, but rather that it is undisputed here that he accepted the tickets through the Joint Appendix 186 that we've been talking about.
he said, the electronic tickets I possessed and my Apple wallet listed name, date, location, event, and so forth. A true, correct copy attached. No terms and conditions appeared on the face of the electronic tickets, nor was there any language on the face of the tickets advising me. And on the paragraph before, he says, I logged in using my Ticketmaster account and assessed the electronic tickets, which I placed in my Apple wallet on my iPhone. He basically says he never saw terms and conditions that he had to go through. Now, my question is there a mechanism by which if he went through this third party where they could have been the ones that went through your terms and conditions and obtained the tickets and then transferred them to him?
No, and again, the record here, and if you look at the Carabajal Declaration, which is.
Well, I saw that declaration, and it made a lot of sense what he said. But I also see the declaration of Gordon, and Gordon categorically says he saw no terms and conditions.
He says he didn't see the terms and conditions through those three dots. He may or may not have clicked on the three dots. He doesn't deny, and he can't deny, I don't think, that he went through this sequence of sign-ins that we're talking about on Joint Appendix 185 to 186.
What if his particular servicer went through it instead of him?
I don't think there's any argument to that effect, but I suppose, Judge Niemeyer, I'll take you back to
Well,
where we
the reason
started
I'm
this
saying
argument.
that is because I'm reading his affidavit here. We're on 136. And he denies everything you're saying about that. I mean, it just leads to the question of fact. How do we resolve this?
I don't think he is denying the key point. If you look at paragraph 7 on Joint Appendix 136, he says, I logged in using my Ticketmaster account and accessed the electronic tickets, which I placed in my Apple Wallet on my iPhone. For all of the reasons we've been discussing and that are established by the Carabajal Declaration, in order to access the electronic tickets through the Ticketmaster website, he has to go through this sequence we're talking about on Joint Appendix 185 and 186. And Joint Appendix 185 and 186 make clear under the standard in the Marshall case that by signing in, he was agreeing to the terms and conditions, and he expressly then clicks agree to the terms and conditions, which included the Washington Commanders.
Why aren't those terms and conditions Ticketmaster's terms and conditions?
I'm sorry, Your Honor?
Why aren't those terms and conditions Ticketmaster's?
Because on Joint Appendix 186, it clearly shows that they're both. They're the Ticketmaster terms and conditions and the Washington Commanders terms and conditions. By buying tickets to a football game, he is accepting both the ticket seller's terms and conditions, Ticketmaster, and the terms and conditions of the football club and the stadium. That's what the layout of this screen clearly indicates. But to go back to your first question in this argument, Judge Niemeyer, if the court has doubts about
He says here, just in response to what you said, no terms and conditions appeared on the face of the electronic tickets, nor was there any language on the face of the tickets advising me that I should click on a link or visit the website to read terms and conditions establishing the agreement.
But Judge Niemeyer, that's referring to the electronic tickets. The only way you get to the electronic tickets is by going through Joint Appendix 185 and 186 first. So whether or not the electronic tickets terms and conditions were, whether or not he saw those, he had to get through these two steps, the sign-in screen on 185 and the agreement to the pop-up on 186. And that, wholly apart from the three dots on the tickets, that is where, under Marshall, a contract was formed. If the court thinks there are factual disputes to resolve about that, however, it should remand for further discovery into what exactly happened here. I don't think that's necessary, though, because I think Joint Appendix 185 and 186 clearly establish a contract.
Okay, thank you.
Thank you, Your Honor.
Did you have your questions answered? I don't.
I might get them. I'll ask later.
Morning, Your Honors. Robert Sokolov on behalf of the appellee. First of all, Judge Niemeyer, you asked the right questions. We were asked to address Marshall. Let me draw a couple of important things with Marshall and a few things that are different. First of all, Marshall found no arbitration. And Marshall, let's remember, started out with a big, bold arbitration thing, listed. There is no such notification in this case. And contrary to what my friend just told the court, it is clear on the record that Mr. Gordon, by the way, is not one of the plaintiffs in this case. Mr. Gordon clicked on, and there were two separate terms and conditions. He clicks on the ticket, I used to call it Ticketron, it just makes me old, Ticketmaster tickets. He clicks on that. He gets to where he has to. When he goes to agree, the rest is not there. He has to go through some separate steps. There is no arbitration.
The argument they make, which might satisfy Marshall, the argument they make is in order to get to the tickets, you have to go through that one page that has the terms and conditions. And when you click on that one page to open it, the terms and conditions pop up and the arbitration clause is right there.
And that is, of course, exactly what Mr. Gordon disagrees with. He says the terms and conditions at at Washington, it disappears. It's a separate box, completely separate. There's nothing in it that suggests
Well, he
you're
did
now
say he
going.
went through the Ticketmaster account, and the question is where in the record is what happens when you go through the Ticketmaster account from your point of view?
Well, my point of view is very simple. It goes back to the affidavit of Gordon, and Gordon is very clear. He says nothing in terms of Washington team goes ahead and tells me, once I click through Ticketmaster, nothing with respect to terms and conditions involving arbitration exists anymore. And I think the importance of both Marshall, which is now, this court's ruling, but more importantly, what the district court found was that it's got to be significantly more. Just any contract, any agreement, any terms are not enough to bind somebody to, avoid their day in court.
But so far so far though, we're only talking about part one of the district court's opinion, which is where the court is explaining why it is not going to grant the team's motion to compel because there's this genuine dispute of fact. But I haven't heard you say anything about the second part of the court's opinion that says, actually, it turns out everything in part one was unnecessary because none of it matters. We're not going to do it. I'm just going to ask you right up front about when I read these Maryland cases, I'm like, this sounds like the exact sort of hostility to arbitration rules the Supreme Court has said over and over and over again you can't have.
Well,
Like, I don't understand how you can say a rule, just because I'm your agent, that means I can check you into a nursing home and I can make healthcare decisions for you and I can do all this other incredibly consequential stuff. But what I can't do is agree to arbitrate. That, to me, sounds like an arbitration hostile rule.
okay, so let me address that. And the only reason I started with the Marshall approach is because the court asked us
No,
to address
totally fair,
that.
totally fair.
So what the court did here was it said, on one hand, it didn't find that there was sufficient evidence in front of it
Right.
in which it compelled arbitration. However, as you, Honor, just pointed out, it then said, well, we don't even have to get to that.
So I know another way to say it, for purposes of part two of the court's opinion, we can and probably should assume for the sake of argument that Gordon would be bound. Because the court says, irrespective of whether Gordon is bound, these folks, as a matter of law, are not bound. And it does so by reference to these Maryland decisions that, again, strike me as the classic sort of thing the FAA says you can't do.
Well, okay, so without being pejorative or discussing, how perhaps the Maryland courts don't like federal arbitration, let me suggest this. There is a logic, and a very strong logic. I think the cases that the court cited to in Maryland perhaps maybe do appear to be, anti-federal arbitration. But if we narrow down and come back to the facts of this case, the facts of this case are much stronger than the facts in which they made those arguments there. For example, one of the things the court pointed out is there's not even an indication that when these tickets were purchased by Gordon, that he even intended to give them to the four plaintiffs in this case. So unlike the nursing home situation, where clearly the people who walk in and say, I'm the agent.
Right.
The
Okay.
problem is, let's take a little more friendly example. A father goes online and buys 4 tickets for his family, his wife and his 2 teenage children, and they go to the football game. Are the terms and conditions under which the father purchased them applicable to the family?
Well, and I think that's the key question, Your Honor. I think.
What's your answer?
Well, the answer is a definite maybe, and here's why. Part of it may be, but there's a big distinction between certain terms.
I don't
and
want a distinction. I want an answer to my hypothetical, and we can go on then from there.
Okay. I would argue no, because the issue of terms and conditions in this case is a very significant one, and that is whether you're waiving your right to go and have your day in court. And I don't think there's any particular case in Maryland on any basis. And by the way, let's remember, Maryland law was argued at the lower court level throughout. Both sides.
So let me go back and ask another variation of Judge Niemeyer's question. So let's go back pre-internet. back when my parents I think this literally happened when I was in high school. My parents got us tickets to the Final Four. And these were back in where they were like big old physical tickets, right? And the back of the physical ticket, I'm sure, said you totally promised to arbitrate if something bad happens to you at Target Field or wherever this was, right? So there's a physical ticket. My parents bought it for me, and either they hand it to me right before we go through the turnstile, or they don't trust me to handle the ticket, so they scan all 4 of them and then we all walk through. Putting aside all of the internet stuff, is there any doubt that in that world I was bound by the arbitration clause? So this is not purchased online. It's a physical ticket my parents bought for me that has an arbitration clause on the back of the physical ticket.
I think the answer to that is, back in the day, when it's a single document, everybody was probably bound by what's on that
Not a
piece
single
of paper.
document. You go up to the ticket counter, and the father buys 4 tickets. And then he takes the 4 tickets and takes his family through the gate and hands the guy the 4 tickets, and the 4 walk in. So now tell me, are all 4 bound by the arbitration clause?
I would say under those circumstances, yes.
Okay, what's the theory?
I'm sorry?
What's the theory?
I think father is buying for children. I think the theory is that there's a more likely scenario that he is acting as the principal in that scenario. I think it's a far different scenario here in which,
Well, you start extending it. You start saying, okay, 4 friends going to a game. And one of them says, I'll get the tickets. So he goes to the ticket counter, gets the 4 tickets. The 4 friends walk in, and the guy hands the 4 tickets to the taker and says, puts them in. It seems to me that when you have people who know they're going to a game with tickets, they have basically agreed with the terms that the person who purchased the tickets.
the big difference here, though, Your Honor, in this new brave world that we live in, unfortunately,
No,
is...
forget about the electronics. I'm trying to take the hypothetical with paper tickets with the terms and conditions on the back. And the father buys the 4 tickets. No, the friend buys the 4 tickets. And the 3 others are standing behind him. They pay their money. And the guy who purchased the tickets has them in his hand. They walk over to the gate, and he hands all 4 to the ticket taker, and all 4 walk in together. And my question is, you said under that circumstance, all 4 are bound by.
Well, Your Honor, if...
Did you
if
say
the-
that? Didn't you say that?
Well, if all 4 walked in,
Yes.
and the person who purchased the tickets handed them to the ticket taker,
Yeah.
which, by the way, is exactly what happened here.
Yeah, it happens all the time.
Right. I don't know for arbitration purposes that that's enough. I don't know that in that instance, the individuals who walk in as the guests are bound by something as serious as an arbitration clause.
Well, they agreed to go to the game, and my assumption is, under the reasoning of the Fifth Circuit, which it seems to me not to be slighted in this case, that when somebody, this is a fact of life in America, somebody buys the tickets, and then they all go, the people who are going are basically agreeing to the same thing that the ticket purchaser agreed to.
Well,
And I
that-
just don't know how we get around that. If we don't get around that, imagine what's going to happen. I mean,
Your Honor, that's a good question. And by the way, all of this could have been avoided. The fact of the matter is, there is a simple way. If they wanted to bind both Mr. Gordon and the others, they could have very easily have had a singular click, not a double click. They could have had a singular
well, let's
click.
forget about that. That's another issue.
That's about whether Gordon's bound. That's not about whether they're.
The question is, we're assuming Gordon is bound. He sees it. He bought this for his friends, and he goes in, and according to him, he handed the tickets to the ticket taker.
Right, but I'm not assuming that Gordon is bound.
But I guess
either.
what I'm saying is I think the part 2 of the district court's opinion assumes that Gordon is bound, because part 2 of the district court's opinion could be Gordon got Cadillac notice. Gordon literally, before he purchased the ticket, was like, are you sure you want, like there's a huge pop-up window and it says, are you sure you want to buy these tickets? Because if you buy these tickets, you're 100% agreeing to arbitrate. And Gordon clicks, yes, I want to buy these tickets. Under part 2 of the district court's opinion, that literally doesn't matter. The fans are still not bound. And that's the part that strikes me as implausible.
Well, let me address both halves of that. First of all, the facts in this case are not kind of the part
100%
one is
agree.
described. So that takes us a long way out of.
No, it doesn't, because I think part 2 of the district court's opinion would say even in that situation, the answer is the same.
And in that regard, Your Honor, I have to say that while the examples you gave, the crazy examples out here, raise some concern, I do believe that it is fair, and under these circumstances, it is fair to say that for an arbitration clause to be affected to a third party, in this case to...
It's not a third party. It's a party who's going to the game and clearly authorizes or agrees to have somebody purchase the tickets, which includes, in the purchase of the tickets, agreeing to arbitration.
But see, that's the point.
Let's stick with the family again.
Right.
The family, the father or the mother buys the 4 tickets, keeps them in his hand, hands them in. He's bound by, whether he reads it or not, it's on the back of the ticket, he's bound by the arbitration clause, terms and conditions of the ticket. It's an adhesion clause, of course. But he's bound under traditional contract principles. And I think it would turn this whole area totally upside down if we said the kids were not bound and the father was.
Your Honor, let me address that 2 ways. First of all, I think the facts in this case are...
Now, please stick with my hypothetical. It helps to understand the principles before we get to this case.
Well, I don't disagree that you could have mayhem. You could have, God forbid, nobody, is applicable to arbitration. However, the flip side of that, Your Honor, is that it could have easily been done in a way without a double click in which...
Stick. How's it going to be done with the family? We got the family buying 4 tickets. The father buys the 4 tickets, and the whole family walks into the gate. He hands them tickets. You say they're bound or they're not bound?
They're not bound if the circumstances are exactly the same here as which the father...
I didn't say the circumstances. Please stick with the hypothetical. We have 4 physical tickets with an arbitration clause on the back of each. And the father buys the 4 tickets and hands them to the ticket taker. And they walk into the game.
So I understand the hypothetical. They're not purchased through Ticketmaster.
No, they're purchased at the gate, right there, ticket.
There, I would argue, you're correct, they would be bound.
Why?
The difference between that...
Okay, now what's the theory?
Well, the theory is that the father was acting as the agent for the family, and right there in front of him it says, when you enter this location, you are going to be bound by arbitration. The difference here is, there's a big question, at least, as to
All
whether...
right, the teenage boy, let's make him an adult. He's 18 years old, and he says, I didn't read any arbitration clause, and he got hurt in the stadium. Under my hypothetical, is he bound by arbitration?
I would say there, more likely, yes, because father is clearly acting as agent, and the ticket he was handed right there, no double click, no anything. He's on notice.
We're not talking about double clicks. I wish you'd get that out of there. It's offensive.
No, I'm saying that the ticket...
It's offensive to change the question.
I'm sorry.
Yeah.
The ticket itself says, right there, clearly, arbitration. There, I believe, under those dual circumstances of a more likely agency agreement and the language being right there saying...
Isn't the agency implied? The 18-year-old didn't say, I agreed.
I think it's implied.
It's implied because the father bought it and they know they were going to the game, and the father purchased the tickets.
That's fair.
All right, so now we'll do the transfer to this case. If Gordon was bound, get the clicks, if Gordon was bound contractually to arbitration, he bought those tickets for 7 others also, and all 7 went in, and he, under his affidavit, he's the one that put his phone there to have them clicked. I've gone to a ball game. That's exactly what you do. You put them on your phone. It's on his phone. The ticket guy clicks on each one, and they all walk in. Now, isn't he acting as the same principle for those 8?
Except for we go back to the beginning, and that is...
No, we're assuming he's bound. We're assuming he's bound.
Well, I don't accept that assumption as being
Well,
applicable
I'm asking
here.
you as a hypothetical then.
So, okay, hypothetically, if he
He's
was...
bound.
If he was
Electronically,
bound,
he has the 8 tickets on his phone.
assuming he was bound, then the question is he reasonably either has authority or apparent authority for these other individuals? And I would argue, no, not necessarily at all. Not at all. Father with kids may be closer. Somebody who's agreed ahead of time may be closer. These are
The
people.
agreement comes by the fact that the one person is buying the tickets for others, and the others take the tickets and agree to go to the game under whatever arrangement they have.
I don't know
And the
that.
fact is, when somebody else is buying the tickets for you, it seems to me the only real-world pragmatic solution is that they're all bound by whatever on that ticket.
And I would argue respectfully, Your Honor, that you can't just automatically bind somebody to waive their rights and end up in arbitration because somebody else bought the ticket for you.
Can I take a
That's
step
big
back then
next
just to
step.
ask you, this was my very first reaction to this case. So one of the basic principles I remember learning in property and other sort of that kind of class in law school is that you can't sell what you don't own, you can't transfer what you don't own. So let's posit, again, this question presumes that Gordon is bound. So Gordon buys 4 tickets, and those 4 tickets convey a right to enter the Washington football team then's stadium. But they also say if you want to enter the Washington football team stadium, you have to arbitrate. We're not letting you in if you don't agree to arbitrate. Let's posit that that's what Gordon was told, right? So Gordon buys 4 tickets that say, I'm allowed to go to a Commander, later renamed Commanders game, but I'm only allowed to go because I agree to arbitrate. And so Gordon's stuck with that. It just seems weird to me that Gordon could then transfer the tickets to someone else, and then the nature of what the right they have is now different. So Gordon only has a right to go to a game subject to an agreement to arbitrate, but now these other people, by virtue of getting the tickets from Gordon, now have a right to go to the game and not arbitrate? Why doesn't that violate the you can't transfer what you don't own principle?
Well, Your Honor, I don't disagree.
It just seems weird, right?
No, I understand the court's concern there.
Like if Gordon said, I'd like to go to the game without arbitrating, they'd say, cool, no.
Well,
But now the fans get to go to the game without agreeing to arbitrate?
well, Your Honor, if those were the facts here, but those were not the facts in all due respect, because remember, Gordon is saying, I was able to click.
I am positing, as Judge Niemeyer is, for purposes of this question,
Right.
that Gordon is required to arbitrate.
Okay, if he's required to arbitrate.
Isn't it then weird to say they get to do something better than what he got?
I don't disagree with Your Honor if those were the facts here.
All right, let's go to the facts. Gordon says, I logged in using my Ticketmaster account and accessed the electronic tickets, which I placed in my Apple wallet.
That's the Ticketmaster tickets.
Right.
Right.
That takes you to what shows on page 184. And the very first click in order to get the tickets is you have to go through the terms and conditions.
Of Ticketron.
Of
Ticketmaster.
Have you got that picture in front of you?
I do not have it right here, Your Honor. but that's-
184.
Right, but that is the Ticketmaster click on.
It says Washington Commanders Account Manager.
Right, oh, I'm sorry. When you say he had to click the next time, he then would have to go.
Well, it says here, put in your email and your password, right here. And then it says sign in. So he clicks in, and the very next page that pops up, and he doesn't deny this, very next page pops up, terms and conditions with the arbitration clause.
And his testimony was that his affidavit testimony was he was able to click on, and he would have to click the second time to get what Your Honor is pointing to.
Show
and he
me
was-
that in his affidavit. I've got it in front of me.
I'm just doing this from memory at the moment, Your Honor.
Well, do you have the affidavit there?
I didn't bring it with me because.
Did you
it's-
bring your brief there?
Yes, Your Honor. But my
You didn't bring the appendix with you?
yes, I have the appendix. But-
Where's appendix?
I'm sorry?
Do you have the appendix with you?
It's on 186, Your Honor.
I said, do you have the appendix with you?
Here, I do not. I do not have it right here. May I make the
Well,
point?
I can suggest to you, he does not say what you just said. He then says, on the tickets, it doesn't tell you. On the
Correct.
tickets, he says, the electronic tickets I possessed in my Apple wallet listed the QR codes, but no terms and conditions. That's accurate, because he shows a picture of it.
Right, and that's what I was trying to say, Your Honor.
I know, but the paragraph before says, I logged in using my Ticketmaster account and accessed the electronic tickets. And in order to log in the Ticketmaster account, he does not include the pages. The defendants do include the pages. And you have to go through the terms and conditions.
Of course, that's a fact in dispute because.
Well, why is it disputed? That's my point.
Because the court determined that it wasn't certain that what was done a year later, to put that together, to put what you're looking at together, whether that was what had to be done a year earlier when Mr. Gordon bought the tickets. So that's a factual dispute, Your Honor, because Mr. Gordon is basically
Who
saying.
disputes it? Have you disputed it?
That was disputed
I'd like
at the
to see
district.
your dispute of it. The way you dispute a fact is with an affidavit or testimony of some kind, right?
Yes, and that was
Okay, and where's the fact that you disputed that?
in the Gordon affidavit, I
I've got it in
believe.
front of me, and it doesn't say that.
Okay. Your Honor, in all due respect, I think the Gordon position is that he was able to click through and not have to have in front of him, much like, by the way, in Marshall that says
Where do you get that from?
from Gordon.
His affidavit?
Yes.
It doesn't say that.
I think that's the meaning of it, Your Honor. If I may say, what's important about Marshall to hear is,
He said, this is all he says about that process. He says nothing negative. He says, I logged in using my Ticketmaster account. You have to have an ID and a password. And accessed the electronic tickets, which I placed in my Apple Wallet on my iPhone. That's all he says about that process. Then next paragraph, he addresses the tickets themselves. And the tickets, as you know, have the 3 dots, and you have to go on the backside.
right. But I think the significance, Your Honor, of Marshall and what the district court found was that if you have to go through that extra step
What step?
to then log into the football team's terms and conditions, which is the only place, but that's the
No.
only place the arbitration shows up.
You're missing the point. When you go into Ticketmaster, and as soon as you click to open Ticketmaster, the very first thing is the terms and conditions. That's what the record shows.
The terms and conditions don't require you at that point to agree to the arbitration. It's when you get to the football team's terms and conditions that you have to go through the arbitration. I think that's the distinction that we're making, and an important
It
distinction.
would have been good if you brought your JA with you. It's not that big a document here.
Well,
And because it doesn't show that.
I don't mean to make excuses like my dog ate my homework, but they're sitting somewhere.
I probably believe it.
They're sitting somewhere on the airplane, Your Honor, when I brought my other file with me, but that's a.
Is that
that's all
true?
there's- Yeah, that's true.
Well, you're excused.
Well,
I understand that.
I'm not asking for the excuse. I think I have it memorized, but yeah, that's.
I'm sorry.
But look, Your Honor, I think what's important here, if I may say in all due respect, Marshall, I think, is really clear. Marshall is telling us that if you're talking about something as important as arbitration, you can't, it can't be a kind of a hide-and-seek kind of arrangement.
Actually, we wrote an opinion last year explaining this, but the Supreme Court has said it again and again. Arbitration is a function of contract, and the gate to get to arbitration is first to get a contract. And if there's a contract that imposes arbitration, then the federal law says it treats it very favorably. And so the question is there contract formation here? And Marshall says basically there can be formation here, especially if you have to click through the terms and conditions to get to the tickets. And I think the undisputed evidence is you had to click through the terms and conditions to get the tickets, right?
Well, that's where I disagree, Your Honor. I think he was able.
Well, that's what I want to hear, where it's disputed.
Well, I believe that what Gordon is saying in his affidavit was, I was able to click on to Ticketmaster. I was able to then see the 3 dots up above. I was able to get my tickets without then signing a separate agreement that says I'm agreeing to the football team's terms and conditions, which included the arbitration. And I think it's very clear, Your Honor, whether we like, Maryland law or not. Right now, Maryland law is that for an arbitration clause to be upheld, it's got to be something fairly significant because you're giving away a fairly significant
Okay.
rule. Thank you, Your Honor.
Yeah, thank you. All right, Mr. Dvoretsky.
So before you start, could I ask you about a question that to me melds issue 1 and issue 2 in this case?
Sure.
Great. Okay, so let's just posit for purpose. I understand you have 3 different arguments about notice to Gordon, right? 3 different arguments. I'm going to call the third argument the 3 dots argument. I want you to just posit that I find that totally unpersuasive, as did the district court, that the 3 dots is not giving notice to Mr. Gordon. So if Mr. Gordon gets notice, it's via one of the other 2. And let's posit that I think you actually have a decent argument on 1 and 2. But then there's the question about how the agency works. So the hypo is this. Mr. Gordon is not their agent when he buys the tickets, but he becomes the agent at latest when he presents the tickets, like the WWE scenario. Like when you let someone scan the tickets for you, they're your agent at that point, right? But what if the only time Mr. Gordon got notice, he wasn't their agent, and that he only becomes, so the WWE example or the family example strikes me, works fine, because let's take the classic tickets example, right? Which is the moment my dad scans the ticket for me, he is in that moment my agent. And in a world in which my dad is getting notice, constructively, fictional, whatever, from the back of the ticket, my dad has notice at the moment he becomes my agent, right? Then there's an alignment of the notice and the agency relationship. What do we do if there's a misalignment between the notice and the agency? What if at the only point Gordon got notice, he's not their agent? Does that matter? And if not, why not?
It doesn't matter because of how apparent authority works.
But he doesn't have any apparent authority when they haven't authorized him to buy tickets for them.
No, but he has apparent authority when he's going into the stadium. And at that point where he is representing himself to the commanders as their agent, and when they are standing there allowing him to swipe them in on his phone as their agent, then he has apparent authority to act on their behalf. And this is what the Fifth Circuit dealt with in Jackson. That apparent authority includes whatever's necessary or proper to achieve the principal's objective. The principal's objective there is to be admitted to the game on a ticket that resides on Gordon's phone.
And let's say if we're thinking of this in apparent authority, the way that cashes out then, if the fans afterwards are like, what are you talking about? You agreed to like, that's a dispute between the fans and Gordon. Like, why did you go and agree to something for me that I didn't want you to agree for and you never should have agreed with?
Correct, because the way apparent authority works, again, under the restatement, is that notice to the agent is imputed to the principal.
But what if he's not an agent when he gets the notice? He gets, at the moment, I'm hypothesizing that when he got notice, he wasn't an agent.
Even if you hypothesize that, it doesn't matter because he's the same person. The only way that he acquired the rights to enter the stadium was by agreeing to that arbitration clause. At that point, he is on notice that this ticket, which was purchased for the benefit of some third party, he wasn't buying 7 seats for himself. This ticket, which was purchased for the benefit of somebody, is subject to that restriction. Then at the gate, that somebody is these plaintiffs. They're the ones who are allowing him to hold himself out as their agent, and who again get them admitted.
And
to
again,
the
so
stadium.
if he in fact went totally rogue and like let's imagine like the worst facts for you, right? Like I want to go to this game, but do not under any circumstances agree to waive my right to go to court. Like the strongest possible version. You would say that in that situation, they might have a lawsuit against him.
Correct, but from the commander's point of view and the way apparent authority works, apparent authority is judged from the perspective of what the commanders would reasonably think. And the commanders would reasonably think in that situation that if he's swiping them in, that he has the power to act for them. And again, industry custom matters here too. Industry custom, Fifth Circuit explains this, informs whether the third party's understanding of an agent's authority is reasonable. And here, it's not only industry custom in the internet age, where people freely transfer electronic tickets and swipe in others on their phone. This goes back to the printed tickets from the Final Four in high school. There, too, if one person swipes in a stack of tickets for others, the industry custom is that it's understood that they can bind the other people to the terms on those tickets. And that carries through to the internet age just as much.
Well,
Counsel, can I ask one question, please?
Yes, please.
Would it make any difference if the person purchased the tickets as a gift? had 4 tickets, went through the process he went through, purchased those tickets, and just gave them to a random 3 other people, and just with an airdrop, young people, I'm talking about, they airdrop your ticket. Yeah, that's pretty good, wasn't it? You airdrop it to them and said, have your way. Would those people, those strangers go in, would they be bound by arbitration?
So I think that goes to the question of whether there's contract formation with them. And I think the way it works is I don't think you can just airdrop the ticket to them. I think the only way that they could acquire those tickets would be to go through a transfer process that takes us back to something like Joint Appendix 185 and 186, where they would have to agree to the terms themselves.
Or exclusively, once you buy the tickets on your phone, download, no one else can get those tickets.
You can't just airdrop it or send them a screenshot or something like that. The only way to do it, the way this actually works, I think, would be to transfer them through the Ticketmaster site or its equivalent, and that would then cause the recipients of those tickets to have to go through the same sort of
That's the
sign.
equivalent, if you take Judge Gregory's hypothetical, let's have physical tickets. He bought 10 World Series tickets, and he gave 9 of them out to friends, just mailed them as gifts, whether they liked it or not, and they go to the game. They're bound. Well, of course, the back of the ticket has the.
Those folks are all bound.
I think
They're bound because they have the back of the ticket.
they're bound because they have the back of the
And
ticket.
so
They're-
your argument is electronically, they're brought back to the physical ticket because they have to go through Ticketmaster.
Right. And those fans would also be bound on, at least on a third-party beneficiary or an estoppel kind of theory, that by going into the game and accepting the benefits of admission to the game, they can't then disclaim the conditions on the back of the ticket.
So it's all kind of fiction anyway, in terms of the notice, isn't it?
The law often is.
Okay, go ahead.
All right, thank you.
Thank you.
Why don't we come down and greet counsel and proceed to the last case? Carolina doesn't have isn't exposed to ex parte Young injunction for enforcement.
That's right, Your Honor. In these particular circumstances, given what the plaintiffs are asking for here, we need to look at the particular officials that they're seeking to enjoin.
Okay, so let's go to the people who do enforce the voting laws in Virginia. So your claim is basically that ex parte Young requires either an individual federal right or an anti-suit injunction. What case says that? I actually as a descriptive matter, I think you're correct that a lot, maybe most, maybe the vast majority of but what case says it is limited to those two situations? Because candidly, I am not aware of a case that says that.
Your Honor, every case that is cited in both briefs fits
Right,
into
that's a
one of those two
factual
categories.
description of what is true in those cases. What case says it is limited to those two situations? Because I have not been able to find a case that says that.
Yes, we would point you to the Michigan Correctional Organization
The
case
Sixth
from
Circuit case.
That's
Okay,
correct.
so no authority of the Supreme Court or this court has ever said that.
Has not said it in such explicit terms, but if you look through every case that is cited in both briefs from this court and from the Supreme Court, every single one of them fits into one of those two
Could you
categories.
tell me about Antrecan and Dobson then?
Yes, absolutely. And I know you were on the panel, both of you, Judge Gregory and Judge Heitens, were on the panel in Dobson. That case actually fits into both categories.
Okay.
It was a Section 19, there are three claims. The third claim was a Section 1983 claim for for due process violation. So that fits very clearly into vindicating an individual right. There were also,
Wait, tell me that again. Just because they sued under 1983, ipso facto, it's an individual right? Why is it an individual right?
1983, they were suing under 1983 to vindicate their right to due process.
Due process, okay.
Yes, that's correct. So the underlying right is the due process right.
Okay.
That is the third claim. The other two claims are seeking to enjoin the enforcement of that North Carolina OSHA enforcement. There were penalties up to, I think, $112,000 worth of citations that were going to be issued against them. So that fits into the equitable anti-suit injunction category.
Don't enforce these things against me.
They're saying, don't enforce these things against me. They are trying to assert in equity a defense that they would have had available to them in law had they been enforced against them at law. So that case fits into both. In Antrecan, there is a recognized federal right to dental care that was at issue there. So in
An
that
individually enforceable federal right to dental care?
case, they were seeking it through Section 1983. So in that case, the
But
district...
did we ever ask whether that statute creates, under the Middlesex clamors, I think, factor? Did we ask those questions, or did we just sort of assume they have an individual right to dental care?
In that case, it was basically just assumed it was not an issue on the appeal. So again, it just fits into that category. If you look at the cases, they either fit into one bucket or the other, or sometimes both, like in Dobson. So I'm happy to go through each case that we cite in the brief, but this case would be something totally different.
So let me flip side. What would happen if these plaintiffs tried to vote? There's going to be an election in Virginia in, a month and a half. What if they showed up and tried to vote? What's going to happen?
They would not be allowed to vote. Their voter registrations are not.
And what if they somehow successfully succeeded in voting? What would happen then?
Yes, I believe that is against the law.
They'd be fined or prosecuted by someone?
I will say, Your Honor, plaintiffs do not make the claim that they are seeking equitable anti-suit injunction. They're several steps before that. They're not saying, we intend to vote, we're going to get prosecuted for it, you need to stop this.
But it is currently illegal for them to vote in Virginia, and they don't think it should be illegal for them to vote in Virginia, right?
That's correct, but that is not, the equitable anti-suit injunction is a very specific remedy in equity that this does not fit into. Professor John Harrison, who I know you know, Judge, he has written extensively on the equitable origins of the anti-suit injunction. Ex parte Young is a great example of that. The plaintiffs there were seeking a defense that they would have had available to them at law in equity to stop the enforcement of or a future indictment under the Minnesota rail.
Sure, they didn't want the AG to impose massive fines on them.
That's exactly right. Here, plaintiffs don't allege that they're going down those roads. So the allegations are they're too far down the road. They have not alleged enough facts to show. And I would say plaintiffs do not argue that they're in the equitable anti-suit injunction. If you look at their brief, they say, yes, some cases fall into one category, but not the other. Some cases fall into the second category, but not the first. They never say, we are seeking an individual right because under the district court's holding, there is no individual right under this statute.
Well, in fairness to them, what they do is they quote Supreme Court decisions that list the requirements for ex parte Young that they claim they satisfy all of them, right? It's Verizon. They have a whole series of Supreme Court cases that say the requirements for ex parte Young are X, Y, and Z. We satisfy X, Y, and Z, therefore we're allowed to sue. That's what they do.
That's right, Your Honor. But Verizon is a great example of that. In that case, this threshold inquiry of whether it fits into one category or the other was not an issue because there was a utility commission order that had already been issued, and the plaintiffs were suing for an anti-suit injunction to stop the enforcement of that order against them. So every case that they point to doesn't have to deal with this threshold inquiry because the threshold inquiry is met. This just doesn't really come up because this is a unique statute. We're talking about this Virginia Readmission Act of 1870. It is something that, as far as I'm aware, other than the Butler case from the EDVA in the 1950s, this is not something that people have tried to enforce.
What difference does that make? I mean, what difference does it make this is something that people normally don't try to enforce when in 1870 it was very clear that that was the basis for which Virginia was admitted and allowed to have congressional representation? What difference does it make that it's justice delayed perhaps? I mean, I see your point, but the question though is that what they're saying, they fit in all those circumstances, and that's what the district court found at this stage. In terms of the governor fits in that stage because the governor is the only person that can restore rights. And if, for example, if a remedy was given here and say, well, you can no longer do that, what happens to the people who are, because no one else can restore rights. Even the other defendants who register people and do those things, they can't restore. So the people who would be stuck in the middle need someone to restore, be required to restore their rights. So that's assuming we're way down the road there, but at the end, if the plaintiffs prevail, someone has to say, Governor, you have to restore the rights of people. If you stop preventing registration, they may be able to do it and register people, but only he could get them out of that quandary in terms of in that nebulous area of applied for restoration, not given, and therefore they're prohibited. So it becomes a necessary part of just in terms of implementing a remedy for that class of people, wouldn't it be?
I don't think so, Your Honor, for this reason. Plaintiffs don't ask for this court to enjoin the governor to restore them the right to vote. They are complaining about the disenfranchisement at the front end, that when they became felons, they were disenfranchised under Virginia law.
So hypothetically, I realize that you don't think they're going to win this case, but hypothetically, if they were to win this case and they got an injunction against the general registrars and all the election officials that says, you may not prevent me from voting, what you view that alone would allow them to register and show up to vote without any involvement of the governor or the secretary of the Commonwealth? That's
right. I want to be very clear about this. There are two separate powers. There's the disenfranchisement power and there's the reenfranchisement power.
Their theory is they were never validly disenfranchised in the first place.
That's exactly right. The reenfranchisement power is particularly ill-suited for judicial review. That's what the Supreme Court said in Ohio Parole Authority and the Connecticut Board of Pardons. So for this court to enjoin, this goes back to where I started, for this court to enjoin the governor and the secretary to have to re-enfranchise these folks would be well beyond the judicial purview.
I guess in the same, if you think about a habeas case, right, we don't need to order the governor to pardon someone. We just need to order the warden to stop holding them. And you say, well, why am I stopping holding them? It's because we've declared a legal nullity the conviction that was the basis of you holding them in the first place. You now no longer have a basis to hold them.
That's right, Your Honor. If you look at their allegations and what they are seeking here, there's nothing particularly that the governor or the secretary do that's necessary here. They do not ask, they say the governor and the secretary, or the governor specifically, is mentioned in Article 2, Section 1. He's mentioned for the reenfranchisement power. So when they say that they're trying to have enjoin defendants from enforcing Article 2, Section 1, taken literally, that would mean that he can't reenfranchise anymore. That's not obviously what they're asking for. So what they must be asking for is for the governor to have to reenfranchise them.
Can I ask you a couple of questions about the foreclosing equitable remedies?
Sure.
Step one, did you ever make that argument before the district court ever?
That particular argument is here before this court because of the way the district court ruled.
So that's a no?
That is a no. That is correct, Your Honor. Okay. We didn't make that specific argument. What we did, and I'm going to explain to you how we got here. We had, there are two separate claims under the Virginia Readmission Act that are in plaintiff's complaint. One is under Section 1983, and one is under Principles of Ex Parte Young. The Section 1983 claim, the district court ruled correctly that there's no individual federal rights under the Virginia Readmission Act, but allowed the federal equity claim to go forward. So, and ruled in the process of doing that Armstrong did not foreclose equitable relief. This court in Antrim, the Supreme Court in Verizon, and Seminole Tribe have always looked at that as a jurisdictional question. So when that was the ruling that we got from the district court, and we, just because of the sort of odd circumstances of how we got here, that's why we appealed under that theory.
So let me ask you that. Let's assume, for the sake of argument, it's properly before us. So let's say, why is this like Antrim? So if, as I understand your argument is, that Congress could, if it discovered a violation of the Virginia Readmission Act, expel Virginia's representatives, which is a remedy. But why does that suggest that it's the only remedy, and how do you particularly square that with Antrocan? Because what you would say in Antrocan is, if the secretary discovers that you're not following Medicaid rules, I can withdraw your Medicaid funding. But in Antrocan, we said that is not enough to foreclose equitable remedies.
That's right, but Antrocan obviously predates Armstrong. I think you'd have to look at Antrocan in light of Armstrong. Armstrong dealt with a similar issue under the Medicaid Act about whether equitable relief was foreclosed. And the two factors that Armstrong looked at were whether the remedy was the sole one and the judicial unadministrability of that statute. Here, the remedy is Congress can kick out Virginia's delegation. That has, every court that has looked at this statute has held that. The Butler Court in the EDVA, the Arkansas Supreme Court, and 8 justices on the Fifth Circuit have all looked at this statute and said Congress is the only enforcer of it. So the remedy that is in the statute is for Congress to remove Virginia's delegation. Then
What happens if a state enacts a law that clearly violates federal law, which didn't create any rights, but this case, how do you enjoin the state from doing that? I mean, it seems to me, if it's a black and white situation and the state passes a statute that's contrary to federal law, a federal statute, Ex parte Young would suggest you don't have to go through this hoops and decide whether there's a remedy under the federal law or not. You have a state law that adversely affects me, and I want to enjoin that law.
That's right, Your Honor. There would be two paths for you to go forward. One would be an anti-suit injunction. So like I was talking about with Judge Heitens, to say...
I don't want to wait for a suit or a threat of a suit. I want to enjoin it. I want to vote.
So if you had a individual federal right, we agree that the threshold inquiry would not be
They don't
relevant
have a
here.
federal right. What we have is a state statute that violates federal law.
Right. So in that situation where all we have is
And the state statute's denying me of a right.
Correct.
Of a fundamental right to vote.
So if it was a fundamental right to vote, you could make some sort of 14th Amendment, 15th Amendment argument. That would then fall into that first category that we talked about where you're trying to vindicate a federal right. If it is just an argument where there's a state statute that violates a federal statute, no individual right, not seeking an anti-suit injunction, at that point, I would point you to Armstrong. Congress has the ability to allow vindication of federal law with federal actors. And at that point, because of not fitting into the threshold inquiry, and then also Congress limiting equitable relief based off of the two factors that we just talked about, it would be in those sort of unique situations that there would be not a way to vindicate it as a private party.
I understand that you have ways of distinguishing it, said it wasn't properly presented, point out that parts of the opinion are actually good for you. Is there any way for us to write an opinion agreeing with you on this without necessarily saying that part of the Fifth Circuit's analysis is wrong? Is there any way to do that?
Yes, Your Honor.
What, they didn't consider this argument? Like what, but no, other than they didn't consider this argument, that they reached the bottom line wrong answer on that question.
So I see my time's expired. May I answer your question? I think a couple things. First of all, the governor and the secretary very easily.
They're different, I get it.
For the actual question about here, I think it's a Pennhurst question where there are two different provisions of the Readmission Act, where this one has to do with the right to vote, the other one has to do with school rights and privileges. There are differences between those provisions that could create daylight.
Could theoretically create a different result.
Could create a different result. I also think that it is very relevant that the district court or the Fifth Circuit there did not consider the threshold question that we've been talking about, as well as any congressional limitations on equitable relief. Unless there are any further questions, I'll save my time for rebuttal.
Thank you.
Thank you.
All right. We'll hear from Ms. Monty.
May it please the court, my name is Brittany Amati, and I represent appellees Tati Abu King and Tony Heath Johnson. The scope of this appeal is limited to a single issue under the collateral order doctrine, and that is whether the district court properly determined that the Ex parte Young exception to sovereign immunity applies here. That question under Dobson requires only a straightforward inquiry into whether the complaint alleges an ongoing violation of federal law and seeks relief properly characterized as prospective, and both are true here. The complaint, for example, in paragraphs 108 and 110, alleges that appellant's ongoing enforcement of Article 2, Section 1 of the Virginia Constitution violates the Virginia Readmission Act, a federal statute. And the complaint seeks prospective injunctive relief against ongoing unlawful enforcement of Article 2, Section 1.
How is the governor engaged in any ongoing unlawful enforcement?
Two responses to that, Your Honor. With respect to the governor and the secretary, there's no dispute that the governor is explicitly named in the very provision that is at issue.
I don't see why that matters even a little bit.
And here, the governor is responsible for ongoing.
How? He's not preventing anyone from voting. He's just not restoring people's rights, which admittedly he could do. But how is that enforcing the ongoing violation?
The governor and the secretary acting on the governor's behalf have unilateral discretion as to whether to re-enfranchise.
Yeah, but let
individuals
me give you that hypo that I gave your friend on the other side about a habeas situation. That's like saying because the president could pardon anyone whose conviction violates federal law, the president is enforcing their illegal sentence in every 2255 proceeding. But no one thinks that's true, because what the court does if it grants post-conviction or habeas relief is it just orders the court not to hold the person anymore. It orders the warden to free them, but we don't bring the governor into habeas cases. Even though he could pardon people, even though he absolutely could, he could fix this whole problem. Any person who's like wrongfully detained in habeas, the governor could just fix this problem by pardoning them, but we don't say that means the governor is enforcing the underlying criminal conviction.
I think this case is distinguishable from those cases in cases like the Doyle case because the
Could you
governor.
just speak up a little bit?
Sure.
We're all across the room here.
Yes, Your Honor. Sorry
you.
about that. I apologize. I think this case is distinguishable from cases such as your example, Your Honor, as well as the Doyle case, because the governor has unique authority to re-enfranchise individuals who apply to have their rights restored.
The governor has unique
And
authority to pardon people convicted of crimes. That doesn't get you anywhere.
But I think here where you have
And you're not asking for him to exercise discretion to restore this man's rights. You're attacking the Virginia provision, aren't you?
we have sought broad
I mean,
injunctive
you don't want
relief.
that. That's an insurmountable problem for you to have a mandatory injunction telling the governor he has to exercise a discretionary act of restoring rights.
Well, I
mean,
think-
I don't know why you want to even take that upon yourself.
Well, I think, Your Honor, the governor and the secretary are included in this case because we want to ensure that the plaintiffs in this case and other individuals similarly situated can receive full relief here. And I have not heard a representation from the other side that they will be able to obtain that full relief.
But how
with the
couldn't
parties
they?
in the case.
Because you simply obtain an injunction against the local registers of elections and against the Department of Elections and says, to the extent Virginia law would otherwise require you to strike this person's name from the rolls, don't strike this person's name from the rolls. To the extent that Virginia law would otherwise, when this person shows up to register, require you to say no, don't follow Virginia law. So let these people, leave them on the rolls and let them register, and when they try to vote, let them vote. How is that not complete relief?
Your Honor, we would submit that we believe that relief is possible.
So why do I need the governor or the secretary of the Commonwealth?
Well, Your Honor, the government has taken the position, including in its blue brief at pages 2 and 5 through 6, that the disenfranchisement is, quote, automatic.
Right.
And so we want to ensure that the plaintiffs in this case can obtain complete relief without the governor and the secretary in the case.
Right, but I just hypothesized an injunction that it seems to me would give you complete relief without the governor and without the secretary.
It doesn't even give you complete relief. I mean, restoration requires the governor to consider it under, I don't know what circumstances, but it gives him authority to restore rights. But your gripe is that the Constitution of Virginia violates the federal law, right?
That's correct, Your Honor. And to the extent that the other defendants in the case will concede that complete relief can be determined from those individuals in the case without the governor and the secretary, plaintiffs would be happy to proceed in that fashion. However, our concern is that they have taken the position that the disenfranchisement is automatic and suggested that maybe they don't believe that having those individuals in the case can lead to complete relief here.
Can I ask you a different question just about conceptually? So in part, this is asking you to respond to something the state says. Their argument is that you're really seeking to enforce the Constitution of 1868 or 5. You know what I'm talking about. They assert that what you're really seeking to enforce is not federal law, but an earlier Virginia Constitution. And so do you concede that if tomorrow Congress repealed the Virginia Admission Act. Just straight up clean repeal, right? A bill to repeal the Virginia Admission Act. If Congress did that tomorrow, this case would have to be dismissed, right?
If Congress repealed the statute that we are suing.
The Virginia
under,
Readmission Act, the very statute that you claim they're currently violating. If Congress repealed that statute tomorrow, this case ends, correct?
I believe that.
Because there would be no basis for prospective relief based on the statute, and because of sovereign immunity, you couldn't get retrospective relief for what you claim was like 100 years of violation of that statute, but none of that matters because you can't get damages relief.
I think that would be correct, Your Honor.
Okay.
But to your question about the 1869 Constitution, just to be clear,
Yeah.
we are not alleging
Sure.
that the 1869 Constitution should remain in place or seeking compliance with that provision. If I could address just briefly, Your Honor, with respect to the arguments related to individual rights, there is not a federal case that we are aware of, and I don't believe other than the Michigan case from the Sixth Circuit that my friends on the other side have pointed to any that render that a requirement for asserting a federal equity cause of action as we have asserted here. In the Supreme Court and in the Armstrong case and in Quirin have made
Well,
clear.
let me ask you this about that. They don't articulate it because it's a strange point to make. It seems to me if a plaintiff comes in and seeks simply to enjoin something that violates federal law and that person has no rights, it's almost a standing issue type of thing. Here, there's a fundamental underlying right to vote, isn't it? And the right to vote was guaranteed by the federal act and has been infringed by the Virginia Constitution. That's your point, isn't it?
We agree, Your Honor, yes.
And, I mean, this is not, this is a right that he's trying to vindicate, is the right to vote, isn't it? I don't know where you're going to place that right, but I guess in the 14th Amendment, I guess.
We agree that there's rights-creating language within the Readmission Act. It explicitly references the rights of citizens or classes of citizens and the right to vote. The district court dismissed our 1983 cause of action, and that issue is not, we were not able to bring that as an appellate issue here. But we certainly maintain our position that the Virginia Readmission Act itself has rights-creating language. And if I could just say a couple words on the Williams
The act
case.
itself, the federal act itself assures the right to vote, doesn't it?
Yes, Your Honor.
As a condition for
Correct.
admission of the Virginia.
Correct, a fundamental condition of readmission, and it explicitly references the right to vote in the Readmission Act. And with respect to the argument related to the anti-suit injunction, that is not the standard under Dobson and under the Supreme Court's precedent. The standard is whether prospective relief has been sought, and that's certainly true here. And for example, in the Antrican case, the relief that was being sought was to bring the North Carolina Medicaid program into compliance with the Medicaid Act and not to prohibit an enforcement action against the plaintiffs in that case. And the same is true here. We're seeking to bring the state law into compliance with the federal statute in the Virginia Readmission Act. And the last point I'd just like to address that was raised by the other side here is the intent to foreclose equitable relief. We don't believe that that's properly before this court under Dobson.
I would have been inclined to agree with you, but how do you possibly square that with the fact that Antrican and Seminole Tribe both considered that in an appeal from the denial of a motion to dismiss under Ex parte? Like they both of those cases considered this intent to foreclose issue in the context of an interlocutory appeal about sovereign immunity, didn't they?
They did, Your Honor.
So how do I square your argument that it's not properly before us with the fact that the Supreme Court and this court have both done precisely the thing you say we're not supposed to do?
I think both in the Antrican case and specifically in the Antrican case, I don't believe this argument was raised. And I think Dobson makes clear that the inquiry as to whether Ex parte Young exception applies is a straightforward inquiry that requires those two prongs.
Okay, but what about Seminole Tribe, where the court literally calls this jurisdictional?
Your Honor, I think looking at the collateral order doctrine.
No, but
and
the Supreme Court of the
narrow-
United States literally calls this jurisdictional in Seminole Tribe. What do I do with that? How do I explain, notwithstanding the fact that they've done it, we've done it, and they've called it jurisdictional, I still can't do it?
Your Honor, it may be jurisdictional, but it's not the specific sovereign immunity question. There are other jurisdictional issues such as standing that this court has held are not to be addressed under the collateral order doctrine in a interlocutory appeal of right, which is a fairly extreme remedy here. But even if this court were to address the intent to foreclose equitable relief here, we believe that there is no intent to foreclose equitable relief in the Virginia Readmission Act for two reasons. First, the Readmission Act does not contain any enforcement remedies for its violation. In fact, the appellants have pointed to the fact that Congress could expel Virginia's representatives from Congress, but the act itself doesn't lay out any procedures for such expulsion or define that as a particular remedy that is available. And as we explained in our brief, in the red brief at 52 to 53.
I mean, by readmitting Virginia, the federal government let Virginia have its representatives back. So I guess the argument is, the obvious implication is, and if you violate this, you don't get the thing that this act otherwise gives you, right? Because the act itself is what gives Virginia its representation back.
That's correct for readmission into Congress and representation. However, I think this case is distinguishable from, for example, Armstrong and from Seminole Tribe, where you had an explicit remedy that was laid out in the statute, and that led the court to conclude that that was the only remedy that was available. There's no such explicit remedy laid out in the Virginia Readmission Act here, and so we don't believe that it falls within the intent to foreclose equitable relief. And for the second reason, that this is not a case involving judicially unadministrable standards, as you had, for example, in the Armstrong case, where there was language that was particularly committed to the expertise of the agency. Here, we're talking about statutory interpretation.
Just look at things that were felonies in 1868, and that's
Correct,
then we're
Your
basically
Honor.
done.
That's correct, Your Honor, yes. And so we don't believe there's any intent to foreclose equitable relief here. And unless the court has further questions.
All right, thank you very much.
Thank you, Your Honor.
Gallagher.
You probably saw this coming. So why doesn't the fact that she's conceded that the minute Congress repeals the Virginia Readmission Act, this entire lawsuit goes away, doesn't that demonstrate that this is seeking prospective injunctive relief for violation of federal law, not seeking to reinforce the 1868 Constitution of Virginia?
I want to answer your question, Judge Heitens, and I want to answer it in light of what Judge Niemeyer was also asking.
Fair enough.
So we have to look at what the Virginia Readmission Act does. The Virginia Readmission Act does not itself protect the rights. It does not create the rights. I think you heard from my friend on the other side that there is rights-creating language in the Virginia Readmission Act. That is not the case. If you look at the text of the Virginia Readmission Act, it says that Congress or Virginia cannot amend or change its constitution to remove the right to vote from a citizen or class of citizens that is entitled to vote by the Constitution herein recognized. So what?
That's just federal law incorporating state law standards. We do that all the time.
Your Honor, I don't believe that that is incorporating the federal law, or the state law standard. I think that this is closer to the Bragg situation this court dealt with in 2001. There are minimum federal standards that are being laid out here, which is you can't amend or change your constitution in these ways. But what is actually being enforced, if there were to be an injunction issued, it would be saying that these people have the right to vote. Where does the right to vote come from in this case? It is from the 1869 Constitution. It is.
But if we repeal the Virginia Admission Act tomorrow, it's gone. So that suggests that the right comes from the Virginia Readmission Act.
I don't think that's right, Your Honor. So
let me rephrase. Absent the Virginia Readmission Act, Virginia can change its constitution in any old way it wants as long as it doesn't violate the federal constitution, right? They can, absent the Readmission Act, and again, absent a 14th or 15th Amendment argument that we'll just posit away for the sake of argument, but absent federal constitutional constraints, absent a federal statute, states can change their constitution anytime they want to in any way they want to.
But in this particular instance, I think what plaintiffs want the Virginia Readmission Act to say is that Virginia can't amend its constitution to do this. What it says is it can't amend its constitution to remove the right to vote for people who have been recognized to have the right to vote under this constitution in the future. So what I'm saying is it is not just federal law telling the state what it can do in its constitution. It is state constitution to state constitution. Think about what we'd have to do if this got back to the district court. the district court have to look at the 1869 Constitution, say what rights were protected, what classes of citizens were allowed to vote in 1869. And then in 1971, is there a match there or is there a disconnect? And then only at that point would there be a violation of the federal law.
Sure.
So the right that is being protected
But
is
that's
from,
because federal law says that's what the district court's supposed to do, right?
if there was an amendment or change that changed the right that was recognized in 1869. I understand this is a very unique statute. And our only point is that in this particular unique context, what they are seeking to do is not enforce the federal law. It is trying to vindicate the right to vote as under the 1869 Constitution. I also want to make a point about, you've heard several times from my friend on the other side, that it's a straightforward inquiry into the factors of whether there's ongoing federal violation and prospective relief sought. Verizon says that in the very next paragraph, it goes into the jurisdictional question about whether Congress has foreclosed equitable relief. If that is all that there is to an ex parte Young claim, there would never have been that second paragraph in Verizon. This court would never look at whether the defendant in waste management and McBurney, it would never look at whether the defendant is the properly named defendant. It is not just those two factors that are relevant. There's the threshold inquiry about whether it fits into one of the two categories. It's a look at whether Congress has foreclosed equitable relief, and that you also have to see if the defendant is the proper defendant. And finally, I want to mention Antracan. Antracan, my friend on the other side said it's not an equitable anti-suit injunction. We've never made that argument. If you look at our brief, I believe it's page 22, we put that in the category of individual right. I think Judge Heitens, you and I were talking about that. But there is in that particular case, there's a Section 1983 cause of action for individual federal right to dental care. It is not an equitable anti-suit injunction. It is the individual federal right. Unless there are any further questions, we would ask this court to reverse the district court with instructions to dismiss.
One question, when you said that it was not Congress' intent here to give equitable relief, did you say that in this act, the VRA?
We believe that Congress, based on the Armstrong factors, has limited equitable relief in this case, that the remedy here is for Congress to remove Virginia's delegation if it chooses to do so.
And you think that's the sole remedy?
Yes, we do, Your Honor.
But you have no case law for that?
Butler from EDVA in 1950, the Arkansas Supreme Court case Merritt, and then eight judges of the Fifth Circuit have looked at this, have looked at different Readmission Act statutes. The Virginia one is Virginia's, but the other two are different ones and have come to the conclusion that Congress is the enforcer, Your Honor.
But you have to look at what Congress' intent was with this statute, don't you?
We look at the statutory text to determine the intent. That's right.
Yeah, what was the intent then? The intent was to, matter of fact, Virginia was the first state, I think, that was removed from a federal district, military district. It was District 1. And part of it, they were one of the first ones relieved. Mississippi, I think, may have been the last one. I mean, there was a strong force here because they knew what they were going to do to the newly freed persons. They didn't trust Virginia to do anything. So they said, look, you can't do anything other than, that's why they said now. Felonies, that common law felonies that exist now. And you're saying that the only remedy, the intent was that once you have Congress people here, we have to take them out of Congress? That'd be just an incredible, you couldn't do that. I mean, that would be just, you said the only remedy that was, okay, you represent Virginia in Congress and the Senate, we're going to force you out of the Capitol. That's what you saying is the only remedy was meant?
That's right, Your Honor. We have to look at the nature of what the Virginia Readmission Act is. It is a contract, essentially, between Congress and Virginia. If you want to have congressional delegation in Congress, you need to do these
It's not a contract in that sense. It's a contract to make our country equal. We fought a civil war to try to heal our nation's wounds. And this was a way to say that this is a demonstrable way to show that everybody should be treated equal, potentially franchisement. It was not just some widgets. You know, it's not about widgets. It's about people and about rights. And so to say that, oh, we can't do anything about it because the whole world would have to turn upside down in order to give a remedy, I don't think so. Just to do the right thing. And that's what that's why they're here in terms of court. And at this point, do we know what the governor's role is really? Do we have facts, the depositions, and how that works, and how does he filter them out? Does he, for example, well, if it's not a common law, if it's this, maybe I'll give it to you. Maybe we don't know that, do we? So
there actually is factual development in the record on this exact point, Your Honor. Plaintiffs
Your
did not,
deposition?
not deposition.
Oh, that's the best way to do it for the only person that can restore rights.
Understood. Two answers to that, Your Honor. First of all, plaintiffs did not put anything in the record on this point, whereas defendants put in the affidavit from the Secretary of the Commonwealth as well as the Commissioner of Elections. And the whole point about the governor and the secretary being the proper defendants here goes to what relief would be ordered. Plaintiffs don't, I believe you heard from the other side, they don't ask for an order ordering the governor to re-enfranchise anybody. So the governor just is not involved in the disenfranchisement that's at issue here.
Well, the district court said it was. So the appellate court, three of us should decide whether that the district court was wrong in doing so?
That's correct, Your Honor.
On facts, or the case, solely because of the case you cite, right?
For this particular point, we've cited several cases from this court about who is the proper defendant in an ex parte Young suit. McBurney, Gilmore, and Limehouse. All of those cases point toward that. And then I would just reiterate that the factual record is completely all of our information. It was an affidavit from the Secretary of the Commonwealth as well as the Commissioner of Elections. Plaintiff put on no evidence about this question.
You do know Virginia has one of the most powerful governors in the country in terms of rights, in terms of privileges, in terms of appointments. It's unique from state to state. In Virginia, I think the governor has broader powers than many other states.
It is unique. And
Right.
sorry.
Go ahead. No, go ahead.
All I was going to say is, in the record, in the affidavit that we put in from the secretary, it goes through that the governor has a re-enfranchisement process in place. He's re-enfranchised thousands of felons over the course of his 2.5 years in office. So he's taking this duty in the Virginia Constitution very seriously, Your Honor. Unless there are any further questions, we would ask the court to reverse.
Thank you.
Thank you.
We'll come down and Great Council will have to adjourn court until tomorrow.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.